Rise, justices of the Appellate Division, Supreme Court, First Department. Please leave all first time business to the Appellate Division. Draw near, if your sentence shall be heard. Please be seated. Good afternoon, lawyers. Welcome to the First Department. Before I call today's calendar, I wanted to underscore how proud we are that today is the first time in our court's history that we have an all-Latino bench. It is difficult for me to overstate the importance of ensuring that our judiciary reflect the makeup of our citizenry. For one thing, I believe that diversity on the bench lends credibility to a justice system that underrepresented groups such as women and people of color have historically viewed with suspicion and distrust. There's a genuine need for citizens to see themselves reflected in the judges who serve them. Because a diverse judiciary, I believe that engenders confidence that courts, the last bastion of justice, have the requisite moral authority to dispense justice for all. So I'm gratified, I can't express that any more strongly than that our court is among the most diverse in the nation. And today, all Latina bench, a happenstance of our randomized judicial assignment system, is just another indication of the progress our society has made. Although there is more work to be done, I think New Yorkers can be proud of how far we have come. So with that, I will begin the call of the calendar. Many of you are aware of the fact that out of 21 cases, 19 are scheduled to be argued today. That will take us, if we give you all of the time that you've requested, that will take us over 7 hours. Obviously, that we cannot do that. So when you're asking for time, please keep in mind that we're going to have 19 cases being argued. Remember that we are very familiar with your cases. We are very familiar with your briefs and the records in this case, maybe more familiar than you would like. So please keep your request to a reasonable. Ask for the time that you need, not the time that you want, okay? So let's begin with People versus Jose Felix.
It was brought from Mr. Felix and request 8 and 2.
Okay, so I will do 6 and 2 and 6. Maraschi versus Trinity Church. Mr. Maraschi? Yes. Okay, do we have Trinity Church here? Mr. Maraschi, do you still want to argue or? Okay, what we'll do is we'll give you 1 minute just so that you can tell us what we should be focusing on. But remember, we have read all of your documents. We have read and quite familiar with the issues in this case. Okay? So we'll give you 2 minutes. And Simon versus Joshua. Appellant Joshua is not here. Do you tell me who you are?
I'm the attorney for the child.
Okay, do you wish to submit? We read your brief, excellent brief describing what actually took place in the courtroom, which the court appreciates it after having gone through all of the transcripts.
Your Honor, if no one has any questions, I will.
Okay, we're good. Thank you so much.
Thank you, Your Honor.
People versus Nieves is submitted. Golden versus Alphawit LLC. Let me hear from Appellant Golden. Mr. Golden, you are appearing pro se. And respondents?
However, 8 minutes, please.
Okay, we'll give appellant 4 minutes and 1 in rebuttal. We will give respondent Alphawit 5 minutes.
Okay, thank you.
Lin versus Wong. Appellant. Appellant Lin, 5 and 2.
Respondents Wong, Ann, and Nancy.
Okay.
And for respondent Zhang, 5 minutes, please.
Okay, 5, 2, 5, and 5. Thank you.
Thank you.
Valdez versus Upper Creston and Gio Cornell. Appellant Gio Cornell. Can you raise your voice, please?
It's the best I can do, Judge.
Okay.
3 and 2.
And Valdez? We don't have a respondent here, counsel. Do you wish to submit?
I will, if none of the judges have questions, I'll submit.
Questions? I think we're good. Thank you.
Thank you.
So submit it. People versus Nesbitt. Submit it. Deutsche Bank versus Oliveras Cruz.
Appellant 6 and 2, please.
Okay. Great. ELM suspension versus 45 East 33rd Street.
Appellant 5 and 2.
Appellant ELM 5 and 2.
Respondent 5, Your Honor.
5 and 2 and 5. Thank you, counsel. Lambert versus Bonilla. Okay, 5 and 3 and 4. Williams versus Martino.
Good afternoon, Your Honor. For petitioners, appellants, rightly said 8 and 2.
Okay, do we have respondents Martino?
Respondent, Your Honor, 7.
Okay, so let's do 6 and 2 and 6. People versus Davis.
Appellant requests 5 and 2. Respondent requests 5.
Okay, 5 and 2 and 5 for the people. People versus Rodney. Appellant Rodney.
Good morning, appellant. I request 4 and 1.
Respondent requests 4.
4 and 1 and 4. Panacea Estate, Appellant Panacea? Do we have cross appellant respondent 29 West 19 condominium? Okay, when I call the case, please stand up. So let me first hear from appellant Panacea Estate. No, we already called that, right? No. So Panacea Estate, what I'm going to do is I'm going to give 6 and 2 to the Panacea Estate, and then 6 and 2 to 29 West 29 condominium.
Your Honor, 29 West submitted through NICE a letter saying they're not appearing today. But I represent the co-respondent, MKF Realty Corp.
Okay.
And I'm requesting respectfully 6 minutes.
6? Okay, you got it. Okay, Bolovsky versus City of New York, petitioner Bolovsky.
Appellant 6 and 2, Your Honor.
6 and 2 and 5. Exportaciones del Futuro versus Authentic Brand.
Appellant 8 and 2, Your Honor. Respondent 4.
Okay, so we'll do Exportaciones del Futuro, 6 and 2. Authentic Brand, 4. People versus Smalls. Submitted. People versus Woodley. Tell me who you are for appellant. So appellants 5 and 1. People. Okay, 5 and 1 and 5. Montgomery versus 215 Christie. Appellant Montgomery.
2 and 1, please.
2 and 1. And Christie? 2. 2 and 1 and 2. And Klein versus New York City Transit Authority is submitted. First case on the calendar, People versus Philly.
Good afternoon, Your Honors. May it please the Court, Taylor Poore with the Office of the Appellate Defender on behalf of Jose Felix. The trial court failed to properly analyze a decade's worth of unsubstantiated bad acts evidence that the prosecution introduced at Mr. Felix's trial, violating Molina. The allegations at issue were uncountable. They included allegations the pretrial motions court had already dismissed, and they filled no evidentiary gaps that were not already addressed by the evidence supporting the charged acts.
Why was it not necessary to introduce the uncharged acts to provide necessary background and basically to complete the narrative, which has been usually the exception to the introduction of uncharged acts, right?
Because the narrative was already fully complete based on the evidence supporting the charged acts. So for every example of evidence that the prosecution has proposed that would fill in those gaps, the evidence already came from the charged acts. So when the
You don't think that Julie's behavior was so unusual that it requires some explanation to the jury?
I think that that explanation was fully provided by the evidence supporting the charged acts. Specifically, she testified that the first incident occurred when she was 12 years old, and she explained that at the time, she was told to keep it a secret and that she was afraid her family would disown her if she found out. She additionally testified about acts that occurred later that were charged against Mr. Felix, and in the course of that testimony, she explained that, again, she felt that she was under his control, There was no escalation in the acts and the interactions. All of that was already provided by the testimony supporting the charged acts themselves.
But so you don't, I mean, some of the charged acts relate to sexual conduct when she was 12 years old, right?
Yes.
So you don't think that the jury is usually not within the realm of common, ordinary knowledge to understand why someone, a woman under those circumstances will continue to engage in conduct as an adult, right? I mean, we heard the explanation from the experts, but you
Yes.
don't think the jury really needs to understand the context in which that took place to complete the testimony that was provided to the jury?
So in addition to the expert testimony, which you've just referred to, Your Honor, Julie herself explained exactly why there was a gap in her reporting, that the reporting was delayed, that she didn't tell anybody until more than a decade after the first incident. She told the jurors directly that she felt she wanted to continue a relationship because she wanted control. She provided all of these explanations, all the explanations that Your Honor is referring to, she provided in the context of the evidence of the charged acts. So in general, Moliner...
But isn't that precisely the problem? Do you think that she really understands some of the psychological issues that, for example, Dr. Meltzer talked about, and why a woman under those circumstances would choose to continue to engage in conduct that began when she was a 12-year-old girl?
To the extent that that evidence was something that she could provide by her own testimony, she provided it in the context of the charged acts. To the extent that it was not something that she was equipped to explain in a psychological context, that was provided by the expert. The uncharged acts evidence was not adding anything to that mix, and it was extremely prejudicial to Mr. Felix's case. It created an unfair trial, and additionally, it wasn't the only instance of, obviously, evidence that should never have come before the jury that did come before the jury. So there was also the evidence, the photographs of Mr. Felix's tattoo. Before ever getting to balancing the prejudice versus the probative value of those tattoo photographs, the court should have realized that the photos were not at all legally relevant and that therefore they were inadmissible as a threshold matter. So whether Mr. Felix had the tattoo was never at issue. Jurors understood that it existed and that it existed before 2004 when the first incident allegedly occurred. The photos of the tattoo did not make the allegations any more or less likely to be true, and so the court should never have admitted them.
Well, why isn't the introduction of the second photograph covering more than the pelvic area, why isn't that harmless?
If I could just respond to that, and
I'll
then
let
I'd
you
like to
respond.
address sentencing and rebuttal if I have time.
No, I'll let you respond.
Thank you. So the second photograph depicts Mr. Felix's face. He's understandably scowling at the camera. Frankly, he looks mean. And I think it only compounds the error. First of all, it should have been analyzed separately to the first photograph, but the harm was already done by that point, as it had been published to the jury without being shown to the defense. And because of the inclusion of Mr. Felix's face, it's not a pleasant facial expression, there is even more risk that jurors made a decision about whether he was guilty based on that second photograph alone.
Okay, thank you.
Thank you.
May it please the court, Victoria Muth for the people. All of the contested evidence was properly admitted at trial.
Why wasn't that second photograph shown to the defense?
I can't say that that was the best practice, but it certainly wasn't unduly prejudicial in this case, and any error would have been harmless.
But whether harmless or not, you agree that...
Was that best practice? No, it wasn't. It certainly was not.
Okay.
But the photographs were plainly relevant to a material issue at trial in that they were objective, corroborative evidence of Julie's testimony. That evidence should have only been excluded if they were solely admitted to arouse the emotions of the jury, which of course here they were not. And while the photos might have been embarrassing to defendant, they were certainly not incriminating. and they were certainly not any more prejudicial than the evidence of defendant in the controlled phone calls or in his text messages, essentially admitting his conduct. As for the Molyneux evidence, a number of courts in the state have routinely allowed the history between a victim and defendant to come in as relevant background information to explain the nature of the relationship between the victim and the defendant, to explain the victim's state of mind during the charged conduct, and to place the charged conduct here in a believable context. And the evidence that defendant sexually abused Julie throughout her adolescence was plainly admissible for those purposes. The jury needed to understand the 10-year gap that happened between the first charged incident and the following rapes that occurred when she was an adult.
And the reason there's a gap, if my memory serves me correct, is that this child was sexually abused on a monthly basis
At least as frequently.
for years.
Correct.
And so she was unable to say on date, January 27th and on February 3rd, like that. As a kid, she was not able to record those dates, correct?
That's correct, Your Honor.
That's why those charges were dismissed from the initial indictment, correct?
That's absolutely right. And just because the charges were dismissed, that's an irrelevant and separate
This was a
issue.
friendly question.
I appreciate it.
All right, go ahead.
I would say yes and move on.
That evidence established the pattern of sexual abuse that Julie endured and internalized throughout her adolescence, which helped the Julie understand the level of coercive control that defendant was able to exert over her even into her adulthood. If the jury had not heard this information, they could have very well believed that perhaps Julie had a quote-unquote consensual relationship as an adult, which of course she did not. I'll briefly address the sentencing point. The facts of defendant's
But
crime.
why wasn't Dr. Meltzer's opinion, I mean, I assume that got to the jury. Why isn't that sufficient to explain the unusual aspect of that conduct?
The jury would have had nothing to apply that knowledge to if they didn't have the facts of the case. It would have been meaningless to them. They needed something to apply that to,
Okay.
which they did here. As for defendant's sentence, the facts of his crime speak for themselves, and the magnitude of his conduct alone warrants the sentence he received. The defendant exploited his position of trust as the victim's primary caregiver to prey upon him. Defendant fails to see the irony that the so-called mitigating factors that he points to are exactly what enabled him to get away with this conduct for so long. And if this type of crime isn't deserving of a heavy punishment, then that begs the question of what is. If there are no further questions from the bench, I ask that you to affirm.
Thank you.
Just briefly returning to the Molyneux issue, Your Honors, the issue here is that the court did not ever do the proper analysis of the different incidents in question. So the law is very clear that it is the prosecutor's burden to get an advance ruling on every piece of bad acts evidence that it wants to introduce so that the court can perform the analysis of whether the evidence is actually narrowly tailored to the required evidentiary purpose. That didn't happen here, and the defense had no opportunity to effectively confront this decades worth of unsubstantiated allegations. As for sentencing, Mr. Felix had no record whatsoever. He was a building superintendent for 15 years. He has support from the community and from his family. 25 years is an excessive sentence in this case.
Counsel, how long did this conduct last? From the age of 12, the defendant sexually assaulted his stepdaughter, right? And what was the duration of years? Was it 11 years that's alleged, that are alleged?
It sounds just over a decade, Judge.
Pardon?
Just over a decade, I believe.
Over a decade since she was 12, right?
Yes.
And you're arguing that a 25 years aggregate sentence is excessive, is that right?
I am, Your Honor. I'm not here to deny the seriousness of the case, but 25 years is the equivalent of
At what point did
murder
he
sentence.
express remorse, counsel?
I'm sorry?
At what point did the defendant express remorse?
Mr. Felix has maintained his innocence, and at sentencing, he put forth, through his lawyer, an extensive catalog of letters from his community and from his family members.
Does that answer my question?
Judge, I'm not here to deny the seriousness of the allegations. Again, I just...
Yeah, but the question is whether, usually when you engage in sexual abuse with a 12-year-old stepdaughter, I mean, it is important for some contrition to be shown, right? I mean, he got 25 years. He still doesn't, express remorse and contrition about some of the acts, for example, engaged as an adult, right?
I believe he did express remorse for the acts engaged in when the complainant was
He
an
tries
adult,
to
Your Honor.
blame her, though, for the conduct when he was an adult, when she was an adult, right?
I believe that he expressed on the controlled phone calls extensive remorse for the portions of that,
Okay.
that portion of the relationship.
Okay, thank you, counsel. Thank you both. Maraschi?
Your Honor, thank you for the opportunity to introduce my case. My case was dismissed by Supreme Court on Foley Square in June. And this dismissal, I appealed, and this is what I'm in front of you. So the court was influenced.
Do you realize, Mr. Maraschi, that the court below was at a loss to explain what happened to you, absent some medical opinion about what the white powder was, what it did to your body, etc.?
Yeah.
So do you understand that?
Yeah, I understand completely. But what happened? The court was heavily influenced by their lawyers. And lawyers, they were ignored by the defendant, Trinity Church on Wall Street. They didn't let them to learn about the case. They are lawyers outside. They didn't go inside the case. And this is why the case is abnormal. It's absolutely just dismissed. And I appreciate Barbara, your honor. She made the decision and she allowed me to appeal. My honor, when I got the letter of the respondent, I see in this letter the same thing, denying my course of action and liability of the security guard. Absolutely. They said that my conclusionary case of action, and what their case, when they denied liability, the guy hit me with this powder spray, and they said he was working not in a professional scope. It's just unbelievable.
Okay.
I came here not only protect myself, I came here to protect the Supreme Court on Foley Square. We are New Yorkers. We believe that our protector number one is a court on Foley Square. It was abused by the lawyers, and lawyers, I don't blame even them. They were not allowed to go inside the case.
Okay.
This is what the situation. Please
Okay.
consider my case.
We will look at your case very carefully. We already have
I
looked at the documents. Thank you, Mr. Maraschi.
Thank you very
Appreciate it.
much. Thank you. Sorry.
Golden versus Allfoy.
Thank you, Your Honors. The order of the lower court seems to dismiss almost all the evidence that I supplied in a summary judgment, and specifically there are 6 counts of this case. Their latter 4 counts, they follow out of the actions of the first 2, which is breach of contract and religious persecution. So mostly I'll talk about that. On the breach of contract.
Why do you think that it is religious persecution when you have a balanced policy that addresses any wearing of jewelry, whether it's religious or not?
Of
right?
course.
That's the case here.
Of course. So to answer that question, it's very simple. First of all, and I listed that in the summary judgment and in the appeal papers as well, there was no such policy. The only paper, and I brought it here as well, the only policy they had was an advisory. It literally says advisory. Avoid putting jewelry, hair accessories that have small parts or party clothing on children. And there is a reason right after loss or damage such items is not responsibility of center staff. And the only
That's not the only reason, sir. Children swallow things. They put small items in their mouth and then they choke.
Yes, sir.
So a daycare center who is responsible for the care of your child while they are in the daycare center's custody needs to be sure that these children are all safe. And seems perfectly reasonable that there be a policy of no jewelry.
Well, there are 3 reasons that I will list to what you are saying. Number 1, in the day-to-day, and I wrote that in the initial summary judgment, in day-to-day operations of the center, children use small items, smaller than the Star of David my son was wearing, constantly. Some with supervision, some without supervision. I even listed pictures from the company website which show children playing with much smaller items than the Star of
And
David.
didn't that happen, sir, with respect to your own daughter, that your own daughter swallowed or was a necklace that had a dolphin on it?
Yes, there are.
Why do you think that it's discriminatory for the daycare center to say across the board, well, we don't really want this to happen with any child, so no jewelry?
Yes, Your Honor. So that's the second point. The second point is that the only instance where there was such a situation was with my daughter several years before they stopped denying my son the ability to wear a Star of David.
Mr. Golden, are you really asking us to concede that there should be an equal opportunity choking hazard?
Your Honor, if I may just answer your question. Yes, so the reason, number 1, Star of David is firmly attached to a necklace, okay? Number 2, in the instance, going back to the original question, the instance of my daughter, she had 2 necklaces on. One was just a decorative dolphin necklace, which she couldn't choke on. She was playing with it in her mouth, with her teeth. It was attached to a necklace. When the school asked me not to put it on her anymore, I said, not a problem. The reasoning made sense. However, at the same time, and I produced that email as evidence as well, I said, but religious jewelry specifically should be an exception. And they agreed with that. I picked up the dolphin necklace from
Where is the agreement memorialized, sir?
I'm sorry?
Where is the agreement memorialized?
Well, the conversation was verbal. However, I presented several pieces of evidence, specifically photographs. So my daughter was wearing Star of David afterwards on multiple occasions while at the center with no objections. There's never been another objection from the dolphin situation that happened several years before until the defendants basically began a targeted campaign against me due to their own personal malice, due to their own personal feelings towards me. They tried different approaches, and the last one that they used was religious persecution. But once again, I did use examples where not only did they agree to to exempt, I asked him to exempt religious jewelry. They didn't oppose to that. And there were photos afterwards of how they proved that they did agree because my daughter did wear a
Thank you,
Star
Mr. Golden. Thank you. You got a minute coming back later. Let me hear from the other side.
Okay.
Good afternoon, Your Honors. My name is Jeffrey Hellerman of the law firm of Raven and Colby, and I represent all the respondents. Just make 2 points. To paraphrase the late Chief Justice Kaye's opening paragraph in her opinion in Forrest versus Jewish Guild for the Blind, 3 New York 3rd, 295, religious discrimination and harassment, including anti-Semitism, has no place in society. Anti-discrimination laws must therefore be strictly enforced to root out this scourge whenever it occurs. But it is simply not the law that every dispute that arises between people of different religious beliefs, including between co-religionists, constitutes religious discrimination, or that every allegedly wrongful act perpetrated during the course of such a dispute is committed because of religion. Simply put, in the case before you, Your Honors, the animosity between 2 divorced parents and between one of those parents and a child's school is not actionable. And then my second point is, in the reply brief, in Mr. Golden's reply brief, the appellant's reply brief, for no valid reason, he reveals the last name of his ex-wife, who is also the mother of his minor children. A stipulation so ordered in the court below by Justice Barak on October 30th, 2019, directs that her full name be redacted, and that's in the record at page 460, and it was an exhibit in our motion for summary judgment below. Also, it's inexplicable what he did on the reply brief, because on his brief in chief, he properly referred to the mother of his children as Yocasta M. Appellant's attacks in his reply brief against Yocasta M. and his frivolous allegations of a vast conspiracy between her and respondents further support that plaintiff's action was properly dismissed on summary judgment. As Justice Kelly held below, respondents' policy does not distinguish between religious jewelry and purely aesthetic jewelry. In other words, the respondent had a neutral policy that treated secular and religious expression through jewelry on pre-kindergarten children equally. We ask that the court affirm the decision below in its entirety. Thank you.
Thank you, counsel. Okay, Mr. Golden, I'll give you a minute.
Yes, thank you, Your Honor. So, first of all, once again, there was no policy. When there were other small parts.
Mr. Golden, over here.
Oh, sorry.
Okay. Question I have for you. Aside from the jewelry, were your children allowed to express their religious beliefs by wearing clothing or in some other way other than with the jewelry, because the daycare believed that the jewelry was a hazardous to the children because they could choke on it?
Yes.
So if you wanted to express their beliefs, did you have other ways to do that other than through jewelry?
I understand. So my children at the time, specifically my son, who wasn't allowed to wear a Star of David, was only 4 years old at the time. We're not a deeply religious family where we wear a lot of religious clothing and whatnot. So the only way we do express our religion to others is by wearing Star of David. There's other ways like Shabbat at home, mezuzah, different traditions. But as far as attire-related things that they could express, especially at that age, was not of an expressions or whatnot, but it was just a Star of David. This is something that I'm an immigrant from Soviet Union, and the only thing that I remember as a Jew in Soviet Union is that Jews, Star of David is symbol of Judaism.
But wearing some type of clothing attire was not prohibited by the daycare, was it?
I don't know. I haven't tried putting something else on. I do know that that was the only time when I did wear it, and again, put on my children, excuse me, in the past it was allowed, as I demonstrated photographs. Other small items were removed from my son when he was sleeping, like, for example, hair tie for him. But this particular instance, they stuck to the guns, but it was only after a bunch of other conflicts arose, which is reasonable to believe that they did it in retaliatory way, even in their interrogatories, which I gave them during discovery. I asked what rules do they allege that I violated, and they listed rules that I violated way after all those events, that supposedly I showed up 5 minutes early to their center with my daughter to a class, and that's the reason that I broke the rules.
Okay. Thank you, Mr. Golden.
Thank you, Your Honor.
Thank you both. Ling versus Wong et al.
Oh, good afternoon.
Good afternoon, Counsel.
Guy Regev here of Zucker and Regev for the appellant. The case involves a then 32-year-old female. As you're
We're
all very
quite familiar
familiar
with the facts, so let's get into the legal issues.
Sure. I would just like to point out the primary issue here is still the issue of fact that exists between the experts, and that was the primary reason that the case was dismissed based on the summary judgment motion. And I just wanted to point out the two primary issues with regards to the issues of fact here, and one of them occurred on the August 6th, 2014, which was the date of delivery, and the other occurred on August 21st, 2014, which was the date of the dilation and curettage procedure. And what the experts say on the plaintiff side here, on the appellant side, is that on August 6, 2014, as you know, the issue here is Asherman syndrome or scarring of the uterus that resulted ultimately. And what they say is that on August 6, 2014, there was a delivery in which normally the placenta would be delivered and examined to make sure it is complete. And in this case, the expert says that it was not properly examined, and we know that because not only was there not sufficient record of that in the actual report, but also we know that part of the placenta was left over, was left back in the uterus itself.
So if I understand, so the issue is not necessarily whether Dr. Wang pulled or used force to deliver the placenta. The question was whether she determined that the placenta had completely been expelled, correct?
Actually, that's the second point I was going to get to, which is you needed to examine the placenta, but also, as you pointed out, during the delivery itself, our expert states that excessive force was applied to pull the placenta out, which caused there to be a disengagement tear in the umbilical cord, and that caused it to become more difficult to then deliver the placenta as well. So those two things occurred on that first date of August 6, 2014.
Can the umbilical cord separate without being pulled?
No. What you're supposed to do is actually wait. According to, again, we have that in the expert affirmation, is to wait for a certain amount of time. I believe it was 15 minutes or so, and that way it is supposed to come out on its own. If you don't
I
wait...
don't think you understood the question. My colleague, I believe, was asking whether the umbilical cord would become disengaged from the placenta itself without being pulled.
The answer is no. The only way it would become disengaged is if somebody pulled on it inappropriately. You're not supposed to pull on the cord while the placenta is coming out.
Now, in the defendant's affidavit, the doctor affirmatively states that she did not pull on the umbilical cord.
Absolutely.
Okay, she says she did not, right? Your expert says the fact that it became disengaged is proof that she pulled too much.
Correct.
Other than defendant's doctor saying that she did not pull, does the affidavit in any way explain medically why there's proof that she didn't pull? Does she support, in other words, does defendant's doctor in her affidavit or in any of the defendant's expert affidavits, provide a clinical reason why they believe there is proof to support Dr. Wong's assertion that she did not pull
No,
on
Your
the
Honor.
umbilical cord.
No, Your Honor.
So that both conclusions are just that, conclusions. Dr. Wong's conclusion that she didn't pull, and your expert's conclusion that she did too much.
If I may, just to follow up on the word conclusion, and obviously it has legal ramifications in
Right.
terms of saying it's conclusory, as long as, according to my understanding of the case law, as long as you're relying on the record, on facts that are in the record, in this case, the fact would be that the cord became disengaged. So our expert relied on the record and facts in the record and provided his opinion as to what the ramifications of that medically are. And the
Did this
conclusion...
patient have any pre-delivery complications with her pregnancy that would have indicated any problems with placenta, implantation, anything?
No, Your Honor.
Did she have a normal pregnancy
Yes, Your Honor.
without any issues occurring concerning the placenta, its position in the uterus, nothing?
Correct.
Okay.
And I did not get to just the second point on August 21st. I don't know how you'd
I'll
like-
give you 30 seconds on that.
Thank you so much. So while the first point had to do with the removal of the placenta, obviously what that led to is then the retention of the placenta, and then on August 21st, when it came down to removing that placenta, according to our expert, what was supposed to occur is that gentle curettage should have been performed to remove the remaining placenta. However, what we know based on the pathology report is that most of what was removed and was done completely inappropriately, which was, most of it was the muscular layer, which even the defendants in their depositions agreed, you are not supposed to get to that muscular layer. There are different layers to the uterus, and you're supposed to just get that first layer, not get into the actual muscular layer. That results in Asherman syndrome.
Okay. Thank you, counsel.
Thank you.
Good afternoon, Your Honors.
Good
So,
afternoon.
Counsel, I want to ask you a question at the,
Go ahead.
I'm sorry, did you?
Tell us who you are.
Oh, Gina Bernardi DeFalco. I represent Dr. Wong, the delivering doctor, Dr. Wan, who I don't believe plaintiffs raised any issues against, and his PC, who is vicariously liable for both Dr. Wong and Dr. Zhang.
Okay.
So counsel, my question is, what, with respect to the examination of the placenta once it was outside of the uterus. So from what I see in the record, there's a statement that Dr. Wong examined the placenta to make sure that it was whole and that there were no retained portions of the placenta remaining within the uterus. But at the same time, there's an allegation that the placenta implanted itself inside the uterus, and that's the part that wasn't expelled. Is there an explanation for this in the record? Is this an anomaly, or is this an issue of triable fact that a jury would have to determine?
Well, first of all, the placenta is attached to the uterus, and it separates at delivery, and I think that's clear in the testimony, although I wouldn't have that specific page number. So what ended up happening in this case is she delivered the baby, she put a clamp on the part of the cord that came out with the baby, and before the placenta had a chance to expel itself, she felt in her hands that the cord had separated from the placenta. So it separated before she delivered the placenta.
So when you say
To
that,
your question, Judge Manzanet.
but when you say that, if the umbilical cord had separated, as you say, just on its own, apparently, would that umbilical cord not have fallen out of the vaginal cavity?
Well, it was, right, the cord.
Since it's still attached to the baby?
The cord is, right, the baby comes out, the cord is attached, but it had separated from the placenta.
Precisely, which means it would have come out of the body then, because it's no longer attached to the placenta.
Well, the piece that was attached to the baby came out, and then
Right.
she had to stick her hands in and deliver the placenta.
Right, but I'm saying, once the umbilical cord detaches, it comes out of the body. Correct? There's nothing holding it inside anymore.
Well, I don't know, it's not clear where along the way it detached. It broke somewhere between the baby and the placenta, so the part that
Well,
was
they would, if you get the placenta out whole, you'd be able to tell where it detached. You would be able to tell if the placenta still has the umbilical cord attached to the mass and whether the cut happens a little bit away from the placenta or at the base of the placenta.
The proof is 100% clear that it was not attached. That's why she had to go in and deliver it. I don't think there's any question there. You know, and
So it's not attached to the placenta.
it's not. It's separated from the placenta. That's why she had to go in
And it's
take
not
it out.
attached to the baby either?
Doesn't answer my question.
Well,
Okay.
it was attached to the baby, and it only broke off at the placenta, not
It
at the
just
baby.
broke at one end.
Right.
So then what do you do? So obviously the placenta is still inside her, right?
Right, so she stuck her hands in, she took the placenta out, she roamed her hands around. This is all testimony that she specifically testified she remembered this birth. So any insinuation in the reply brief that this was custom and practice testimony is not true. She specifically said she remembered. That was on page 806 and 815 of the record. She took it out, she stuck her hand back in 2 times, felt around. She looked at the placenta upside down. She made sure the entire membrane is intact. This, she says, she does in every single delivery, not just ones where she has to deliver the placenta manually. Every single delivery she does.
So we go back to my original question, which is, if she examined the placenta and saw that it was whole, how is it that the placenta remains in the uterus? Is this an anomaly, or is this a question that has to be determined by a jury?
This is not a question that has to be determined by a jury. It's not even a question that has to be answered. The question is, what is the standard of care for her to do in that moment? And it's
No, but
to
the
examine.
the standard of care cannot be that portions of the placenta remain in her uterus or her vagina, right?
My expert said it was not a departure for portions to remain behind. Their expert did not dispute that at all.
But counsel, I guess the
Question
difficulty,
only-
counsel,
No,
the
sorry.
difficulty that we're having, I'm just gonna ask it straight, is how can it be that the placenta is whole according to your doctor, and then there's evidence that there was material left behind?
The question is not, was the placenta whole? It was, did she examine it correctly? And from her examination, it appeared whole. From all the symptoms that the woman did not have in the 2 days she remained in the hospital after birth, there was no indication. My expert made it very clear there was no indication to believe that anything had been retained. Their expert didn't come back with anything. All he says is,
So it's possible
oh,
then,
she
counsel.
must not have.
So counsel, so then it's possible that your doctor, when your doctor looked at the placenta, concluded that it was whole when it wasn't.
That is true, but that doesn't address either the standard of care or causation in this case.
So the standard of care, if I'm getting you straight, according to Dr. Wong, the standard of care, if you have to manually remove a placenta from a woman's uterus, is that a hand sweep of the uterus is enough without doing a sonogram, which is the very same procedure that was used that showed the material that was left behind 2 weeks later. Had that been done in the operating room, we wouldn't be here. And this woman would still be able to have children.
That is not necessarily so. If she had, first of all, the sonogram was done because she was bleeding. She was not bleeding in the hospital. My expert said you don't do a sonogram in those situations. Their expert didn't dispute that either.
I'm sorry, was the sonogram performed after the manual extraction of the placenta?
3 weeks later, when she started bleeding profusely, that was the indication. The other thing is, if a sonogram had been done, the testimony is also very clear, it's in there, it's on 827, 828. If a sonogram had been done that day, she would have still had to have a D&C, and the Asherman syndrome, as my colleague will explain, is a risk of the D&C. So
Yes,
there's no...
but are you suggesting, counsel, come on. You're suggesting that having placenta material left behind that becomes necrotic is a better situation than having had the DNC immediately after after the birth?
I'm suggesting.
Clearly, that is not the case. The faster you get this material out, the better outcome you are going to have a chance of having.
There is nothing in the plaintiff's expert affidavit that says any of that. I made my prima facie showing. It was his burden to raise an issue of fact. He didn't. He didn't do that. He didn't put any of those things that you're saying. The expert affidavit has none of that. The issue on the appeal was limited by their brief to one thing, whether or not the proof establishes that she examined the placenta. The proof is very clear. She went through pages and pages of testimony of how she did that. And their expert's testimony is only, she should have looked at the condyles. Doesn't explain what the condyles are, doesn't explain why her testimony shows that she didn't exhibit.
Okay. Let me hear from the other side, Counsel. Thank you.
Thank you, Your Honor.
Good afternoon. May it please the court. My name is Jacqueline Mandel. I represent Dr. Katie Zhang on this appeal. It's our position that the order of the court below should be affirmed. Dr. Zhang established that she treated the plaintiff pursuant to the standard of care, and in opposition, the plaintiff provided only speculative and conclusory opinions about Dr. Zhang, premised on hindsight reasoning that were insufficient to raise an issue of fact. We know that it's the rule in this court that an expert opinion is merely speculative and conclusory, and therefore of no probative value, when the expert fails to address the movement expert's specific and detailed factual assertions. There are numerous examples of that in this case as it pertains to Dr. Zhang. A couple of quick examples would be that Dr. Zhang's expert, Dr. Grazzi, opined that the standard of care in this situation requires that there be curettage until all of the products of conception are evacuated and the hemorrhage that the patient is having is stopped, and that the failure to do that can lead to hypovolemic shock and even death. The plaintiff's expert had nothing to say about that, no opposition whatsoever. Another example, Dr. Grazzi opined that curettage has to be performed until the surgeon appreciates this grittiness. Some surgeons refer to that as a uterine cry. I'm not even sure if that's the right pronunciation, if it's cry or cry, but that's the word. And that tells the surgeon that, in this case, she has reached the appropriate surgical objective. She's reached the level that she needed to get to. Plaintiff's expert said nothing about that. He ignored it. Dr. Zhang's expert said that there has to, that even the most gentle curettage, which Dr. Zhang, of course, said she used in this case, can affect the basal layer of the uterus. Plaintiff's expert said nothing about that. And as my co-defendant's counsel alluded to a moment ago, Dr. Grazzi also offered the opinion that up to 40% of women who have to undergo a postpartum D&C may develop Asherman syndrome, even in the best of hands. No comment from the plaintiff's counsel on that. In fact, the plaintiff's expert never offered an opinion as to what Dr. Zhang did wrong. He never criticized her choice of treatment or her decision to perform the D&C. He didn't criticize the instruments she used or the way that she used them. He never described what it is that she supposedly did wrong. And I'd like to refer this court to its own decision from 2018 cited in my brief called Almanzar versus Rijos. I want to quote it for a second. This court held that where the plaintiff's expert fails to opine as to how or in what manner the procedure was improperly performed, the plaintiff fails to raise a triable issue of fact. That is exactly what happened in this case. That's what Judge Silva ruled, and respectfully, he was right. I'm also just going to, 2 days ago, this court happened to issue a decision in a case called Hashem versus Osorio. I sent copies of the case to both counsel. I have copies for the court if you want the physical copies. It happens that plaintiff's counsel was the appellant in that case as well. And that was also a medical malpractice summary judgment. This court found that the plaintiff failed to raise a triable question of fact, characterizing his expert's opinion as vague and conclusory, and noting that, I want to get this correct, that while the expert disagreed with the use of the treatment, the post-surgical platelet count in that case, the expert failed to explain why. which this court ruled was this is a quote, was a particular flaw where the defendant's expert offered a specific explanation on this issue, and that decision is equally applicable to this case. We gave a detailed explanation, and in response, all that we got was Dr. Zhang must have been overly aggressive because there were some myometrial cells found on pathology. And I take serious issue with what plaintiff's counsel said a few moments ago, that most of the tissue that was there was myometrial tissue. There's no support for that. The pathology report is in the record for this court. They don't tell you how much myometrium was there. They measure the total size of the placenta, which was, 77 by 15 by something. But none of it, there's no sizing on myometrial tissue. It's just some cells. All that this is some hindsight reasoning. And this court has rejected hindsight reasoning over and over and over again, where you say—
Do your experts opine that a DNC that has to be performed postpartum has a site that's more sensitive because of the recent delivery, right? So that a woman who has to have a DNC, perhaps because she is suffering from endometriosis and excessive bleeding, that uterine wall may be better able to absorb the kind of procedure that a DNC is than a uterus that has just delivered.
Correct, Your Honor. My expert said that any postpartum DNC, the tissue is necessarily much softer than it would be in the example that you posed.
Right. And especially so, as in the case here, where she is developing an infection and this material has been left behind and is now creating a massive problem inside.
Correct. She plainly has infection. As you pointed out earlier, the placenta that was removed, there was necrotic tissue, which means dead tissue.
Mm-hmm.
There was chronic inflammation, chronic infection, which my expert explained by itself, putting away the DNC may lead to Asherman's. And for all of those reasons, he reinforced the fact that up to 40% of women who have to undergo a postpartum DNC specifically, even with perfect treatment, 40% may develop Asherman's. It's just kind of the nature of the beast.
Mm-hmm.
My last comment here is, Your Honor, Justice Acosta, I want to refer you to your decision where you're also presiding in Cruz versus New York City Health and Hospitals Corporation, cited in my brief on the issue of hindsight. And I won't take the time, my red light is on, to read it to you, but for all of the reasons that have been discussed and for all of the precedent that this court has on the issue of conclusory experts and the improper use of hindsight reasoning, we respectfully request that the decision for Dr. Zhang be affirmed.
Thank you, Counsel.
Thank you, Your Honor.
Okay, you got 2 minutes, Roboto.
Thank you. Quick response regarding the pathology report findings. Just a quote from the pathology report. It actually states there was, quote, inflamed smooth muscle consistent with myometrium. And that's that layer that in counselor's own or expert affirmation, it states that you should not go past a certain layer that you can actually tell by the scraping cry, they refers to it, that you've reached that layer. So we know they agree you should not be going past that layer, yet the pathology report states there was smooth muscle consistent with myometrium and scant, very small fragments of inflamed endometrium tissue. The inflamed endometrium tissue is the tissue that was supposed to be removed. There was very small parts of that, according to the report, and therefore most of what was removed was that smooth muscle. So to say that counselor disagrees with that, there was no basis or support of that by their expert as well. With regards to any other questions, I would love to answer if there are any.
I only have one question. Defense, there's some talk in the papers about the possibility, the speculation that perhaps the placenta here was deeply entrenched into the uterine wall, and perhaps that's why it did not expose out of the body after the birth. Was there any evidence of that in the record postpartum that would have supported that this placenta had embedded itself deeper than the normal uterine wall lining?
There was not, Your Honor.
Thank you.
Thank you, counsel.
Thank you.
Deutsche Bank. Go ahead, counsel.
Good morning, Your Honors. My name is Gail Blasey, and I represent the defendant, appellant, Carmen Cruz. And it is with profound pleasure that I appear before this panel. The court below, Justice Doris Gonzalez, erred when she granted leave for the plaintiff to recommence this action after reciting a litany of facts which this court has repeatedly held is tantamount to a neglect to prosecute pursuant to 205A. The court, Justice Gonzalez, then switched and granted leave to recommence. This was a contradictory decision, and if the recommencement court had decided based on these facts that Justice Gonzalez did not dismiss.
And that's a different Justice Gonzalez from this one, right?
No, Your Honor, Doris Gonzalez.
Thank you.
Counsel, so Ms. Cruz was not served, right? But an Yvonne Cruz was in fact served. But I find no explanation as to who Yvonne is.
That's correct. And the evidence that Carmen Cruz presented was that she did not live at that address. She lived on Archer Street. She produced her license, she produced a deed, and she...
So she didn't rent, Carmen Cruz did not rent to Yvonne?
I do not know, Your Honor, and I do not know that for a fact. I don't know. Either way, if a person doesn't live at the place they were served, it doesn't matter if they receive notice.
You don't think that there will be issues as to whether she will be, I mean, she rents the space, right? It's a private home.
I have no idea. Yes, it is a private home.
So usually you get to decide whether there is a person of suitable age and discretion that's served at the address owned by Ms. Cruz, right?
But if it is not her, pardon me, Your Honor.
No, go ahead.
If it is not Carmen Cruz's residence or place of employment, it is improper service.
Okay.
But Ms. Cruz did identify the person who received process as a tenant.
No, she did not.
She didn't in
No.
the papers?
Not that I recollect.
Really?
Yeah. Not that I recollect. I think she actually denied knowing an Yvonne Cruz at that address.
I think she called her.
But that matter was never put before the court. The court never decided that issue
Right.
because it never had jurisdiction, which was the whole problem. And in this case, it is res judicata. I know counsel has argued that the recommencement court should decide whether or not the facts recited by Justice Gonzalez was a neglect to prosecute. But because Justice Gonzalez granted a substantial right, that grant of the substantial right is res judicata on the recommencement court. So we're between a rock and a hard place. As a matter of fact, plaintiff did recommence, and in the motion paper stated, well, we have the ability to recommence timely, even though it's time barred, because Justice Gonzalez, in her opinion, gave us leave to recommence. So it was imperative that we come to this court for your decision stating clearly the facts upon which the case was dismissed is neglect to prosecute, and it was error to grant leave to recommence.
Counsel, if I may, just to clarify, in the record at page 260, Ms. Cruz in her affidavit stated that service upon Yvonne Cruz did not constitute a service of process upon her because Yvonne was merely a tenant at the premises. That's the reason why we're asking questions about how did Ms. Cruz know this and whether there was a familial relationship with a person who had the same last name.
And I stand corrected. I have not focused so much on the facts of the service, because even if Yvonne Cruz did accept the papers, that was not Carmen Cruz's residence. And the law clearly states a person must be substituted served at their place of residence or their employment, even if they own the property. That is my understanding, but we never got to that point where she could present. This process server, Jose Rojas, was a notorious sewer server process in 2008 during the time period that this happened. It's questionable whether or not these papers were ever actually served. And if he asked this alleged Yvonne Cruz, do you even know Carmen Cruz? And so the crux of what we want from this court, because we never had a fair opportunity to determine, I don't think there is enough before this court to determine whether or not Ms. Cruz presented enough evidence to warrant a traverse hearing, because we need to get beyond the leave to recommence. Thank you.
Thank you.
Good afternoon, Your Honors. David Gans for the plaintiff, Deutsche Bank. If it may please the court, this defendant are trying to argue a 205A motion within the current action, and that said claims are inappropriate. 205A is to be reserved only for the recommenced action, in which and determination as to whether or not the prior action was dismissed in accordance to her claims of a neglect to prosecute should have been addressed only in the newly recommenced action. Having said that, nonetheless, the actions are not deemed to be a neglect to prosecute. Plaintiffs rely on their response brief on the case of the First Department.
Whose obligation was it to substitute the decedent in the action?
I'm sorry?
Whose obligation was it to substitute the decedent in this action?
So that obligation, it was unclear because of...
Wait a minute, you're the proponent, right?
I am the plaintiff in the action. The decedent had died.
So if you are suing to collect on the mortgage and one of the mortgagors die, you have to move to substitute that party for the party to continue.
Correct. Yeah, correct. It was
that done here?
What?
Was that done?
It was not done here due to in
Why not?
Due to in part to correspondence we were having with counsel that indicated that they, as the deed indicates, that they were husband and wife, and there were representations made to our
counsel. You know how fast it is to run somebody's name and date of birth to find out whether there's a license, a marriage license in the city or state of New York?
So eventually, after the action was filed, we did obtain the deed, and it came to our knowledge at that point when we obtained the death certificate to determine that they were in fact not married. Steps were tried to be taken to substitute the correct wife of Mr. Oliveras. That being said, we were unable to, then the action, because of that, we did not do it as quickly, but it was not deemed a neglect to prosecute because there were steps being done actively, and 1021 has to be deemed is not a merit dismissal unless so indicated by the court. Because Judge Gonzalez did indicate that it was a leave to recommence, it's clearly showing her intention to say that, yes, there are things that may warrant it, but it does not come to the level of neglect to prosecute, and therefore plaintiff should be allowed to recommence a new action. And he claims that defense.
I mean, you waited 3 years to get this process going.
Well, it wasn't. No, because once it's 3 years is an unfair characterization, because once
the action thing. There was no court orders directing substitution. There was no court order. All the cases cited.
So the court has to tell you to substitute the estate of a party you sue who died?
No, so no, but we were taking steps. We were trying to determine who the proper party was and if substitution was necessary. Because if in fact they were husband and wife, then a substitution may not be necessary.
But it doesn't take 3 years to find that out, right?
It took some time till the department gave us the correct, till we obtained the death certificate and made a correct determination as to what was going on.
Okay, thank you, counsel.
It was clearly the plaintiff's obligation to have a fiduciary appointed. As Justice Gonzalez said, they knew it was readily available in 2011 when Mr. Olivares died as to whether or not he was the husband of Carmen Cruz, regardless of what the deed said. In fact, Justice Gonzalez found, quote, while plaintiff attempts to claim that plaintiff was misled by the fact that Cruz and the decedent held themselves out as a married couple, the fact of the death and the papers in surrogate court proceeding, which indicated another person, allegedly the wife of the decedent, were readily obtainable in 2011. 3 years have elapsed since Justice Sherman denied various motions based on the death of the obligor without any effort by plaintiff to effect a substitution. Justice Gonzalez said they offered no cogent reason for at least a 3-year delay.
You'll still have an opportunity to make those arguments on the recommenced action.
We would, Your Honor, if plaintiff was not going to say that Justice Gonzalez's position makes it res judicata.
No. Once you recommence, the issue of the 205A is open. And can be argued.
In most situations, I would agree. The concern here is that Justice Gonzalez granted a substantive right, which is res judicata, which is what plaintiff has argued in the recommenced action.
I mean, he can argue it, right?
You can argue a lot.
Thank you, counsel.
Clarification that it isn't tantamount to a substantial right and that the recommencement court cannot rely on that. They need to examine the facts as they were. Thank you, Your Honors.
Thank you. ELM suspension. Yeah.
His mid-game stretch.
May it please the court, my name is Scott Yaffe. I'm here on behalf of the appellant, ELM Suspension Systems. In order to bring this case and statute of limitations under CPLO 214 and the 3-year period, the courts have interpreted the statute as requiring that there must be a new liability created by statute. There's nothing new about a trust fund liability.
Well, the court found that the RPL 339-1 does more than the traditional constructive trust claim, right?
Well, it found the more being that it gave standing to my client. Not the claim itself is just for trust funds. There's nothing new about that.
And it's similar, we agree, but does the statute track constructive trust common law claim?
I didn't hear.
Or does it do more?
I didn't quite hear all of that, but
I'm sorry.
But what the statute does is it implements common law, the common law claim of
But
trust.
it's not all it does.
Yeah.
That's the question, right? Does it do more
No, it
than a
doesn't do any
traditional
more.
common
Sure,
law?
doesn't it dispense with the necessity of showing a confidential or fiduciary relationship, a promise, a transfer, or reliance thereon? So all of those typical showings that would have to be made under the common law are not necessary now under that statute.
Yes, right. And I want to direct the court's attention to a case that should have been in the briefs. It is the State of New York versus Cortell. This is a Court of Appeals case, 38 New York 2nd, 83. And it's cited with approval in the two of the main cases that are discussed in the briefs, Gaydon and People v. Credit Suisse. And what this case does is it says that extending a common law claim to a new party, a party that would not have standing under the common law, is to be ignored for statute of limitations purposes. Statute of limitations, in this case it had to do with fraud, and it gave the Attorney General the right to bring a claim for fraud. Attorney General didn't have a right under the common law to bring a claim for fraud.
Counsel, that sounds like a stretch. Sorry. That sounds like a stretch. So there's obviously no relationship between the supplier of the scaffold and the condo itself. There's no contract between them. There's no agreement between them. The agreement is between the supplier, who's the plaintiff, and the contractor. And the only way that there's a nexus between the two of them is through 339L2 of the RPL, which says that common charges paid to the condo board equal trust funds for any materials that are for paying for the cost of labor or materials performed or furnished at the request of the manager, the board of managers, or the managing agent. Otherwise, how could there possibly be any lawsuit? So this is all created by statute.
Well,
and that's why your adversary's going to argue that it's 3 years and not 6.
I'm having trouble hearing you.
I have a low voice anyway. That's why your adversary's arguing that it's a 3-year statute of limitations instead of a 6-year statute of limitations.
Yeah, well, two things here. I mean, first, as I was trying to explain, the fact that standing is given to my client, same as in this case, the Attorney General had no right to bring a fraud claim. And the statute gave the Attorney General the right. The statute of limitations for fraud claim is 6 years. The court held that it's 6 years with regard to the Attorney General. You look at the claim, the liability. You do not look at who has standing to.
But you're not seeking, this is not a fraud claim, right?
No, this is a right. This is a trust fund claim. But it's the same, should be the same principle.
This is not the AG.
What?
This is not the AG. These are private parties.
The legal principle that standing is, and it's, I can quote it, but standing does not affect which statute of limitations you have. So just because we have the right. Also, I just want to point out that in New York, this whole area of the law has been preempted for a couple of centuries, I think, by the lien law. In other states, they do not have a lien law. They use constructive trust to give a supplier, like my client, a claim against an owner or a GC who's up the chain. I mean, I'd like to cite a case to you if you would like to see in another state where they apply the common law, this common law.
No, but I mean, we have to focus on the statute and what it provides, right? And the statute, yeah, we have to look at the statute.
Yeah.
Right? Is the statute providing a remedy or a course of action where one did not exist before? And the answer to that is yes, because it's going beyond the traditional constructive trust claim, doesn't it?
No, it's not. That's incorrect.
Okay.
I mean, the fact of the
You have a few minutes to explain to me why.
Okay.
In rebuttal.
Yeah.
Good afternoon, and may it please the court, your honors. I'm Joshua Strickoff of Herrick Feinstein, and I represent the respondent in this matter. This is not an issue of standing. As Your Honors correctly determined, this is an issue of whether or not the liability created by this statute existed before in common law. In this case, it doesn't, and I think it's helpful here to unpack what we mean by liability. And I would point the court to the People v. Schneiderman case. There's a quote from that case cited on page 6 of our brief, and also on page 35 in the record, because the entirety of the decision is actually a part of the appellate record because I annexed it to my underlying trial court case. And there, the court said, in sum, the Martin Act, which was the statute at issue there, imposes numerous obligations or liabilities that did not exist at common law. And that's not a disjunctive or. The or liabilities phrase there is offset by M dashes immediately following the word obligations, and the word liabilities is in quotations. So I think it's pretty clear what the Court of Appeals is saying there is that the Martin Act imposes numerous obligations. In other words, liabilities. So the two words are really synonymous here. And when you apply that to RPL 339L, it's pretty clear that the obligations imposed on condominiums to hold the common charges it collects in trust for the benefit of contractors and laborers who perform work on condominium common elements, that's not a common law liability. That does not exist at common law. You cannot get that in the normal course through a constructive trust claim, through all the reasons that Justice Engoron pretty carefully went through in his underlying decision.
So who's supposed to give him his $96,000 that's owed to him?
Well, Your Honor, it could be the subcontractor that he was directly in contract with. It could be the general contractor that was in contract with the subcontractor. It could be the condominium sponsor and developer that had the contract with the general contractor / construction manager. And under the statute, it creates the statute then creates the backstop that is filled by the void that the lien law left, and does impose that liability then, in that instance, on the condominium. But that's a statutorily imposed form of liability, and because of that, that is why CPLR 214.2 applies, as opposed to CPLR 213.1. If there are no further questions from the panel, then I'll rest on my briefs and thank the panel for its time and attention this afternoon.
I think we're good. Thank you so much.
Thank you.
And so the statute uses the word shall constitute trust funds. That's a command, and that is a use of a common law remedy. The Gaydon Court, as well as all the courts, really, are saying that if a statute uses a common law remedy, now they could have not said that. They could have left those words out. They could have just created a right to sue for the funds against the common law charges. Then we might have a different argument. But here, they have used specifically in an exact express language a common law remedy of trust funds. They press the trust on the funds. And all we're doing is suing for trust funds. So our claim, we're only talking about the statute of limitations for our claim would be that to obtain trust funds. And that would be 6 years under settled law. So that's, and if you look at all their arguments, and you start reading them again in terms of standing, that's really what they're saying. They're saying that we couldn't bring a common law claim. First off, that's not, I don't think that's a relevant argument. But second, we could, and we would believe we could, but New York law doesn't really exist because the lien law was done in early 19th century. And we don't have a body of common law really on this, but other states do. And they use constructive trust for a subcontract supplier like my client against an owner or a GC. And if you'd like, I could refer you to a case, if that would be helpful.
Yeah, I mean, the problem is that the state, that state case, if it's not New York, doesn't really govern 339, right? That's the problem that you're going to have.
No, it's just the general common law.
Yeah, so we have to look at the statute and the intent of the legislature as reflected in the language of the statute.
Right, and the intent was to use the common law. And then if you look at the rule under Gaydon, that says you must apply
Okay.
statute of limitations for a trust fund.
Okay, thank you. Thank you both. Lambert?
Good afternoon, and may it please the court. My name is Richard DiPonto, and I represent the plaintiff in this case. In denying the plaintiff's motion for summary judgment on the issue of liability in this rear-end accident case, the court erred in not only determining and holding that plaintiff failed to establish her prima facie entitled to summary judgment, but also in holding that there was a question of fact as to whether defendant offered a non-negligent explanation in causing this rear-end accident. As this court is aware, it's axiomatic that there's a presumption of negligence when the rear-ending vehicle, the vehicle trailing, rear-ends the lead vehicle in front of it. And that happens when there's the lead vehicle is either stopped or is slowing down. There's no doubt in this case that the defendant rear-ended the plaintiff's vehicle. Now, the point is that the defendant essentially conceded this fact in their opposition papers when at no point in time did they argue that plaintiff did not establish their prima facie entitlement. They don't rely on a single case that the lower court relies on in arguing that summary judgment shouldn't be granted. Their whole opposition is that there's a non-negligent explanation in causing the accident, which you only get to once there's an establishment, a prima facie establishment of summary judgment in a rear accident.
Mr. Bonilla provides more than one explanation to why the accident, why he rear-ended the plaintiff, right?
So, Your Honor, if we're addressing, if we're moving past whether or not the plaintiff established her prima facie entitled to summary judgment, the explanation provided by the defendant driver is that there was a sudden stop, which the courts have generally held as insufficient to rebut the presumption of negligence. And the case is
insufficient by itself, right?
Insufficient by itself. And to highlight this point, the lower court cites a number of cases, Baez-Pena, Tutrani, Newell v. Benson, which those facts are not applicable to this case in the least. Not only is it those cases, all cases where the plaintiff rear-ended the defendant, each one of those cases dealt with an unforeseen and unexpected incident which led to the stopping of the lead vehicle. The Baez-Pena court specifically held that there are cases with markedly different facts than those in Baez-Pena, which would require a different outcome. They specifically cite Diaco v. Junga, which is another First Department case, which is on its points on all four corners. That's a case where the plaintiff was driving on an expressway and observed the defendant traveling in the same lane behind him, approaching his vehicle fast from behind. The defendant testified that he observed the plaintiff pump their brakes, the distance between the two vehicles closed, at which point the plaintiff slammed on their brakes and the defendant rear-ended the plaintiff's vehicle. This court held that based on those facts, that's insufficient to rebut the presumption of negligence. That is the exact facts we have here. It's the defendant testified that the driver of a school bus full of children drove that route every morning, was familiar with that route and the traffic conditions. This was at I-287, a major highway, rush hour traffic on a weekday. But the plaintiff testified that it was heavy traffic. The defendant said that the traffic was moving slowly. My client testified that she was slowing down for her traffic in front of her, saw that the vehicle behind her was approaching her vehicle at a high rate of speed, tapped her brakes to warn the driver and behind her, at which point the issue was rear-ended. Right. It's the same facts as Diaco v. Junga, which this court held was insufficient to rebut a presumption of negligence. And Your Honor, I would also say that in holding that the plaintiffs failed to establish their prima facie entitlement, it also flies in the face of Rodriguez v. City of New York, where you don't have to establish an absence of comparative fault in order to establish liability in a summary judgment context. So in sum, Your Honors, I don't think there's any question that the plaintiff established a prima facie entitlement summary judgment, which then transfers the burden to the defendant to come up with a non-negligent explanation for this rear-end accident. And based on the facts that they presented, that this essentially a conclusory, self-serving statement that she stopped abruptly, notwithstanding the fact that he says he was paying attention, saw the brake lights, and yet couldn't stop his vehicle in time. I would also point to Gutierrez v. Trillium USA, which is another case that says that the plaintiff who was traveling on an expressway during midday rush hour traffic was rear-ended by the defendant who was traveling no more than 30 miles an hour and one car length behind, but couldn't stop his vehicle in time. The VTL specifically holds that you have to be able to maintain a safe
Enough
distance with
distance
prevailing
in
traffic
order to do
conditions.
it, right. Thank you, counsel.
Good afternoon, Your Honors. May it please the court. My name is Mark Jordan Poinsett. I represent the respondent defendant in this matter.
What is the non-negligent reason for rear-ending this car? 'Cause I didn't see it.
Mr. Bonilla stated that she was driving erratically in the affidavit.
That was a delayed memory on the part of your client?
No,
Because in the
It was in the
report at
affidavit.
the accident, in the deposition, said nothing about erratic driving. And now in an affidavit to try to contest the summary judgment motion, all of a sudden there's erratic driving?
I believe
That's called a feigned issue of fact that can be completely ignored by this court. Why should I not ignore that?
I believe plaintiff's own testimony establishes that she was driving erratically. She said she pumped her brakes.
No, she didn't. She didn't say she was driving erratically. She said the cars in front of her were slowing down, and as she is required to do, she has to slow down with the traffic in front of her, as did your client have to do that.
Yes.
So tell me what's negligent about
And
that.
she saw your client in her mirror getting closer and not paying attention, so she kept pumping the brakes in order to cause them to stop or slow down, right?
Correct.
Go ahead.
Mr. Bonilla was not asked directly whether she was driving erratically. He provided that detail for his affidavit in opposition to this summary judgment motion. However, I would say that plaintiff's brake tapping, as I've described it, is what led to him stating that this was an erratic driving.
Didn't your client have an absolute obligation under the VTL when a car in front of you taps their brakes?
Yes.
You have to tap yours because you can't crash into the car in front of you.
That is correct, Your Honor.
So what prevented your client from hitting his brake the way Miss Lambert did?
He told his dispatcher that she stopped suddenly. That is his explanation as to why this happened as it did happen.
Right, but he also, this is where the feigned issues of fact come in play, right? He also said that her brake light, Ms. Lambert's brake light did not illuminate. He said that at the deposition, and then in his affidavit, he contradicted that.
In his affidavit, he meant that while he didn't see, the affidavit didn't speak to the brake lights, it spoke to her slowing down and braking in front of him. That's the distinction between what he was asked at his deposition versus what actually happened in real time when the accident was happening, or prior to the accident happening.
But he's also traveling at he says, with 3 car lengths approximately behind the car.
That's correct. He
And
said
all of a sudden, he's traveling 1 car length or less, which seems to imply that he sped up or was driving really fast.
She claimed it was 2 car lengths. He said it was 3 car lengths before the incident happened. Again, we speak to that as a question of fact as to the traffic conditions at the time the accident actually happened. Ms. Lambert said it was stop and go. He said it was moving medium, heavy, and
Or we can conclude that it was too close, right? 2 or 3 certainly wasn't far enough to prevent hitting her in the back.
For those traffic conditions, that's correct. I mean, he was traveling between 30 and 40 miles per hour. She seemed to be traveling the same speed based on her own testimony about her speed prior to the accident.
Which then leaves us with the logical conclusion that those facts can't be accurate because he would have been able to stop then. If you're only traveling 30 miles an hour and the car that is 2 car lengths ahead of you stops, you should have enough time to stop.
He should have had enough time to stop. He slammed on his brakes. He did the best he could in the situation of her stopping quick. She was traveling, the car in front of her allegedly was 2 car lengths in front of her as well. So everyone seemed to be traveling at about the same pace before this accident happened.
Okay,
All right, thank you, Your Honors.
thank you.
Your Honors, I don't really have any rebuttal. If there are any
Yeah.
questions, then
I think we're good.
thank you.
Thank you. Thank you both. William?
Good afternoon, Your Honors, and may it please the Court. I'm Eric Penzer, represent the appellants in this appeal. While appellate courts give great deference to the verdicts of properly instructed juries, the verdict of an improperly instructed jury is entitled to no such deference. Here, in refusing to give a confidential relationship instruction over the strenuous objections of the petitioner's counsel, the surrogate erroneously relied on the Court of Appeals decision in the Walther case for the proposition that where a relationship can be deemed confidential as a matter of law, a close familial relationship counterbalances any legal presumption. Respondents argue that on this appeal. The surrogate, however, misapprehended Walther, as did the respondents. Under Walther, a familial relationship does not negate the possibility of a confidential relationship and everything that comes with it, including an inference of undue influence and a duty of explanation, provided sufficient circumstantial evidence of undue influence is otherwise presented. That's not me saying this. That's Justice Weber of this court when she was an acting surrogate in the Taschereau case that's cited in our brief, and many other cases.
But the facts here militate against a confidential relationship charge, right?
No, I don't believe that's correct, Your
The facts
Honor.
here are even stronger than in Walther. Are they not?
I'm not sure I understand the question. The facts here you had not only did you have a trustee-beneficiary relationship, which is confidential as a matter of law. There's no case that's ever held that it's not. You have the decedent giving her daughter a power of attorney, a healthcare proxy. And the question is not whether she used those. It's what do they represent in terms of the trust and confidence that you're giving to a person who you give this power to.
But the decedent retained the right to change the co-trustee and the terms of the trust, right?
She did, but that doesn't affect, Your Honor, the fact that think about if you're appointing someone as your co-trustee with the full knowledge that should I become incapacitated, this is the person that's going to care for me. This is the person that's going to make all the decisions under this trust. And in fact, immediately after being appointed co-trustee, Claire started acting as co-trustee. Maybe she didn't make any decisions. We don't know that, but she did. And we know that she went to meetings with Lucille's attorney that they say were for the purpose of trust administration issues.
The attorney spoke on behalf of the clarity of mind that Lucille exhibited in effectuating the 2009 restatement of the will, of the trust, right?
They did say that, and the capacity, the clarity of mind, the capacity wasn't the issue here. Even notwithstanding the clarity of the mind, the jury is still entitled, I respectfully submit, to be instructed as to how to analyze those issues.
But there's a familial relationship in the sense that Claire's the surviving child, her son Don having died as a result of a motorcycle accident. Claire assumes Don's responsibility with respect to his mother, their mother, and she cares for her and, in a sense, replaces Don, except that allegedly, I don't know if she moved in or not, as did Donald. So doesn't Walther tell us that a sense of family duty is inextricably intertwined in this particular relationship, if we look to Walther for guidance?
Respectfully, no, Your Honor. And that's because Walther says that If you have no evidence of undue influence, then yes, the
But
family
where is
relationship
the undue influence? Where do you see signs of coercion or moral, I'm thinking of the case that goes before Walther.
What's the evidence of undue influence is, I think, what you're at. Is that?
Yeah, that's the question.
Okay, well, your honors, this panel, but this court has already pointed out that evidence in affirming the surrogate's denial of summary judgment based on the very same evidence that was offered here at trial. This court said in its prior decision that there's evidence of undue influence. It has
No,
to be
this court said, I sat on that panel, and this court said there was an issue of fact for the jury to decide.
That's right. But
that's what we said. Do not add more to what the prior order said.
But the issue of fact, Your Honor, was because there was evidence of undue influence. That same determination.
Well, but
under
what did
Walther-
the jury conclude is the question, not what we said. We're not the triers of fact.
But the jury should have been instructed properly that, hey, this is not just a mother-daughter relationship. You can find, jury, that because all these things were going on, there's all this evidence of undue influence under Walther, you can find there was a confidential relationship. And if you do, you don't have to, but if you do find that.
I've got to tell you, it seems a little silly to me to say that a mother-daughter and a mother-daughter where the daughter is caring for me as an old lady, that's not automatically a relationship of confidence. That's obvious. As every human being walking the planet knows that. If you have a decent relationship with a parent, so much so that you are taking care of your parent, that's obvious.
But you have more than that here, Judge. You have the daughter getting directly involved in her mother's estate planning, calling the lawyers, making the appointments.
That's exactly what Don did also. That was their job, to oversee and make sure that their mother's estate was okay.
Correct, but when Don did it, up until Don's death, and for a dozen years prior to that, including during the husband's life, the brokerage account issue was split evenly. It was only after Don died and Claire took his place that you see this change. 3 months earlier, 3 months before the restatement here, the decedent executed a prior restatement which left everything to Don and Claire except the brokerage account, which she left equally to everyone. And that was other evidence that this court cited of undue influence in sustaining the summary judgment.
That was evidence we cited that it was an issue of fact for the jury to decide, not that it was evidence of undue influence.
But under Walther, that evidence would also give rise to under Walther, if there is evidence of undue influence, which Your Honors said there was, then that family relationship does not counterbalance the confidential relationship.
Okay, let me hear from the other side.
Thank you.
Good afternoon, Your Honor. My name is Lawrence Rosenstock, and I represent Claire Martino. Your Honor, if I actually may borrow from Gertrude Stein, there's actually no there in this case. There are no facts to support the appeal that they've taken. Your Honors are obviously right. The issue of undue influence has been decided. The jury made that decision, and I think the facts on the record are overwhelming.
But there is no question that the charge here left a little to be desired, counsel. So the question is whether the charge as a whole was fair and sufficient to properly guide the jury, because this was not a model of clarity that I would have preferred.
Well, Your Honor, I think I certainly there's no basis to have directed to have charged as a matter of law that there was a confidential relationship. There was no evidence to even support it. The two key factors for a confidential relationship, even aside from Walther, is that you have to show inequality and you have to show control. Claire did none of those things. The trust specifically said that Lucille alone was going to exercise the duties of the trustee, and only she did it. Counsel's incorrect when he says that Claire was involved in the trust. All she did was become trustee to replace Donald, but she did nothing else about anything until after Lucille died. Lucille, throughout her life, was the one who controlled everything. Her financial advisors, Phil Warden, who also was the financial advisor for her deceased husband and for several of the Williams children, said the same thing. He said he spoke to her all the time about finances. That was not an issue. So there's no basis at all under any state of facts here that could support a collateral, a confidential relationship charge. And there was no even request that it be submitted to the jury, but even if there had been a request, it should not have been submitted to the jury, because before you can do that, you have to show, particularly when there's a mother-daughter relationship, you have to show something extraordinary in order to justify it. You have to show some type of inequality and control. You don't have any of that at all. In fact, it was Lucille. If anybody was controlling anything at that time, it was Lucille. And all the facts demonstrate that Lucille made her own decisions. I mean, one thing that's in the record that we quoted in our brief was the letter that Lucille wrote just after Don died, in her own handwriting. It was an intelligent, lucid, clear letter to her lawyer saying, we have to meet to discuss what we're going to do with my estate planning. This was Lucille talking. She was a smart, intelligent woman. The Williams liked to sort of paint her as being some old lady who didn't know what she was doing. That's totally unsupported by the record. They claim that she was estranged, but she was never estranged from Claire. They had a loving relationship with her and her children all the time. The only people that were estranged were the Williams, who rarely ever saw her, rarely talked to her, and just were sort of mad now that they didn't get part of that brokerage account. That does not justify anything. I think that the charge to the jury was more than sufficient. I think it was clear. I think the surrogate did what she knew was proper in not addressing the confidential relationship charge at all. And I think that it's clear that this decree should be affirmed. If there's any questions more, I would be happy to address them, Your Honor.
I think we're good. Thank you, Mr. Rosenstein.
Thank you.
Your Honors, how many errors in a charge do we need until we can say that the charge as a whole was not fair? Not only do we have the failure to charge as to the confidential relationship, we have the court, the surrogate, over the strenuous objection of the petitioner's counsel repeating its prior ruling about the decedent's capacity, that the capacity is a low...
But the court told the jury that they were free to consider capacity on its own, right?
She did, but then the court went on to say, and by the way, the capacity is the lowest level in the law, and she understood the terms of the instrument. To say that's gilding the lily is an understatement. In addition, the PGI says that you list all the factors that the jury should consider in determining undue influence. This court, again, in a different context, in the summary judgment context, stressed the issue of the decedent's grief. She was inconsolable after her son died. The court says the surrogate properly cited the unexpected traumatic death. It talks about how his death left the decedent, who was in 80s, inconsolable, distressed, further compromised her mental and physical health. These are factors that the jury should have considered in determining her susceptibility.
Is there an issue about the letter that counsel referred to?
Which letter is that?
The handwritten letter?
The handwritten letter by Lucille after her son's death saying, Mr. Lawyer, we need to talk about my estate in order to
Yeah, there is a question about how Claire was involved with all these decisions. I mean, we don't know that because we weren't behind doors, but that's what undue influence is. There's circumstantial evidence that proves this. But as to the issue about the decedent's grief, this court stressed it, the surrogate stressed it, and yet, when asked, Judge, please list this as a factor to consider, because if you don't list it, the jury, you're telling the jury not to consider.
I'm sure counsel argued it vociferously on summation. I'm certain of it.
Thank you, Your Honor.
Thank you both. People versus Davis.
You should just stay standing.
Huh?
You should just stay.
Oh, it's okay. I'll take a break in a little bit.
Good afternoon. Benjamin Rutkin-Becker on behalf of Ronald Davis. Because joinder of these three superficially similar incidents deprived Mr. Davis of a fair trial, this court must reverse his convictions and remit for separate trials.
Counsel, how are the three incidents 3 days in a row committed by someone wearing the same clothes. What was the word that you used, superficially?
Superficially similar, Your Honor.
What's so superficial?
Well, initially, Your Honor, I would note that what distinguishes this case from many other severance claims before this court, and goes directly to your point, is that here severance was unequivocally available. So the prosecution actually has conceded that the jury was required to consider evidence of each of these incidents separately, and never argued that proof of Mr. Davis's guilt of any...
But didn't this court rule in 1991 in People v. Stridford that there's a public interest in avoiding lengthy duplicative trials?
Sure, Your Honor, there's certainly an efficiency interest here that, as the Court of Appeals has noted as far back in People v. Lane, has to be weighed against the defense's fundamental right to a fair trial. And it's clear that as important as this efficiency interest is, that cannot compromise a fair trial. That's exactly what happened here. And to the extent that Your Honors believe that these incidents may have actually borne on each other or been so similar that how could they not be tried together, that's actually the problem here, because again, the jury was supposed to consider them separately. There was just no way that that could happen.
But why is that? I mean, first of all, it's a discretionary decision on the part of the court, right? So basically all of the robberies they each had a video. I understand that one had a clearer video than the other two. But at least one witness was going to testify as to each of the three crimes. So why was that an improvident exercise of discretion?
Sure, Your Honor. So I don't want to quibble. There were videos, but I do think it's important to note that video of the third incident, it was not actually of the third incident. There was a video that maybe showed someone who could have been Mr. Davis. There was similar clothing, sure, in the area. So that's already a significant difference between...
But the jury would have seen it, right? I mean, the jury will look at it, will look at the other two videos, will make a determination as to who was actually shown in that video, right?
And on the third one, I believe that's the case where the shop owner chased him out of the store with a bat.
That's correct, Your Honor.
And so we had a very live witness, very clear about who had robbed him.
Sure, Your Honor, but that witness was unable to make a clear identification at trial.
At the time of trial, but he did at the time of arrest. He had no problem identifying him at the show-up.
Your Honor,
Correct?
that witness...
Or was he the lineup guy?
He was a lineup witness,
Okay.
Your Honor, and I actually think that's quite a meaningful difference, because at the time that the severance motion was renewed here, we knew that the critical witness who actually was at the front of the store, who had really seen the perpetrator far more than the person who chased him out, and had actually identified him in the show-up rather than the lineup, that witness was not going to testify anymore.
Was that witness available?
That witness, I'm not sure what happened to that witness.
I mean, how much time had elapsed between the crimes and the trial? In a small store like that, she probably wasn't employed there anymore.
Sure, I believe the trial testimony was that, in fact, she was no longer employed there. I don't know that that means necessarily she couldn't have testified. I can't speak
Well,
to
they
why
didn't have
she-
control over that witness.
Sure, sure, Your
right.
Honor, and this is not a material witness issue. The point is that there were significant differences between these incidents, and...
But, counsel, we have cases where multiple incident trials with multiple incidents on different days are tried all the time in this state. None of the cases are exactly the same. None of the cases have the same level of weight and of evidence. It's just, it is what it is, and each, the judge instructs the jury, as he did here, correct? That each case had to be determined based on the evidence solely as to that case, that they couldn't compile it, et cetera, correct?
A few answers to that, Your Honor, if I may. I see my light is on. So as to the instruction, when there's such prejudice, as this court has recently acknowledged in the Santiago decision, an instruction cannot undo that. And secondly, here, Your Honors should, on appeal, consider the actual prejudice that Mr. Davis suffered. What the case law, there is a foundational concern about similar seeming, apparently similar crimes being tried together. And in the cases where that has been upheld, I grant, Your Honor, that there are those cases. There has at least been one witness, for example, to identify the individual at trial. There's been overwhelming proof of each incident at trial. To the extent the proof was overwhelming here, that was on aggregate. That's the problem. You have the second incident, for example, with no witness able to identify Mr. Davis at trial. There's a fingerprint lifted from the area on the door where the perpetrator is seen touching on video that does not match Mr. Davis. That's a significant disparity between the first incident, where the video the prosecutor accepts was clearer, and you have an eyewitness identification of both Mr. Davis and the weapon. I don't want to go too past my time, but if there are no further questions, I'll reserve.
We're good.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Carl Dubel for the people. Defendant was properly tried here for all three robberies because there is not a substantially more proof as to one crime compared to the others. That, as Your Honors mentioned, that decision was discretionary, and these crimes were properly joined not because evidence of one was material to the other. They were properly joined because they were defined by same and similar statutory provisions under 200.22c, which is why discretionary joinder is even an option in this case. The proof, obviously, of all three crimes is not going to be exactly equal, but the proof of each crime was very strong, and the judge made very clear that the jury had to examine the evidence of each crime and then only consider defendant's guilt because of that evidence, not because of evidence of other crimes. As Your Honors mentioned before, 2 of the robberies were captured on video. In the first one, Diaz, the eyewitness, identified the defendant in court, and she identified the knife that the defendant used as the same knife that was admitted into evidence. Same with the third robbery. The eyewitness, Chavez, who was the shop owner, was actually not the other witness. He was in the best position to determine defendant's identity because he saw him, defendant pointed the knife at him, and he chased the defendant out of the store with a baseball bat.
Was the knife in plain view? I know that's what Officer Mendez says.
Are you referring to the suppression issue, Your Honor?
Yeah.
Yeah, with the suppression issue, so the court ruled that the knife was properly recovered under 2 bases: search incident to a lawful arrest and plain view. The strongest basis for that ruling is the search incident to arrest doctrine, because the officer who stopped the defendant had viewed, that same morning, had viewed images of defendant committing the robberies. She had viewed a wanted poster of the defendant, and she had that wanted poster in her patrol car that morning. Once she recognized defendant on the street as the person in those videos, that gave her probable cause to arrest defendant for the robberies, and since she had probable cause to arrest, she was lawfully allowed to search his pockets. If there's no further questions on any of the issues that the defendant has raised in his brief, I will just ask that you affirm.
I think we're good. Thank you. We'll give you 1 minute.
Thank you. I would just like to point Your Honors to the jury's deliberations here, which demonstrate that the jury absolutely could not consider the evidence separately. They deliberated for 1 hour before convicting Mr. Davis of all counts, and the jury's ability to disaggregate and an acquittal in some cases is used by
Could that be because the evidence was just overwhelming of your client's guilt?
Well, that's just not the case, Your Honor. I mean, we dispute that the evidence was overwhelming as to any of these incidents, but certainly...
So just to view the evidence, you have video, you have him captured on video committing the robberies. You have witnesses that have picked them out of a lineup, pointed them out at a show-up, and who came in to testify and identified them in court as the person that committed the robberies. That's pretty powerful evidence, isn't it?
Oh, sorry, I didn't mean to interrupt here.
No, no, go ahead.
I would just note respectfully that even that assessment of the evidence was aggregating the cases. If you take the second case, for example, you do not have an eyewitness identification. And courts have long noted the power of having an eyewitness in court saying this is the individual. The video of the second incident really does not show the perpetrator's face. It's also less clear than the first incident. And the prosecutor, after saying they wouldn't do this, in opening and summation referred to this as a spree. In summation, presented the evidence side by side and said you would have to believe essentially that there were two mis-IDs to acquit. They were urging the jury to convict based on the aggregate strength of the evidence, and that deprived Mr. Davis of a fair trial. So reversal should be necessary
Was
here.
that
Thank you.
comment objected to on summation?
It was objected to, Your Honor, and
Did the judge sustain that?
it was not sustained, and we don't bring a separate summation point, but certainly, again, this is the Striteford case. One thing that appellate courts look to when assessing severance claims is how the evidence was presented, and the way that the evidence was presented in these summation comments were certainly relevant, as were the jury's deliberations. I think we have a very strong example of actual prejudice here, and this court should not tolerate such an egregiously prejudicial joinder. Thank you.
Thank you both. Rodney?
Good afternoon, Your Honors, and may it please the court. Nisha Marks for Appellate and Terrence Rodney. A sentence reduction to 2 to 4 years is warranted in this case, which simply involves cashing a check. This was a nonviolent crime where Mr. Rodney made no threats, there were no weapons. He fully cooperated with police.
He got 1 year over the minimum, right?
Correct, Your Honor. He got 3 to 6. We're asking for
And he's a second felony offender.
Correct, Your Honor. But the minimum sentence is taking into account his criminal history, and the guidelines still say that the minimum must be 2 to 4. And Your Honor, I think this is based on a number of factors that are relatively important. Mr. Rodney's personal circumstances, first and foremost. He had significant family ties. He was living with his father, who at the time was 71 years old. He had been living there for about 20 years, and also was the father of 2 teenagers, Kenyatta, who was 17, who was living with him, as well as his daughter, Avion, who was 13 at the time. He also had steady employment. He was contributing financially to the family, and was working at Master Purveyors for about 3 years.
He's also someone who attended community college for 2 years, and in hand he had a forged Connecticut license, a forged Capital One credit card, and a check, all made out to the same name.
Yes, Your Honor. And he did tell probation that he had found them on the street. This isn't a situation where he used any violence to acquire any of this stuff. And again, he did cooperate with the police when he showed up. He didn't run. He did tell them that he had done it. We're not disputing the facts in this case. What we are saying is that
he has a previous conviction for reckless manslaughter?
Correct, Your Honor.
Manslaughter, excuse me.
And again, that is taking into the calculation, which gives us the minimum guidelines of the 2 to 4, which again, we do think is warranted based on all those family circumstances, but as well as his taking into account his cognitive disabilities, which was not before the trial court at the time. He did go to a school from a young age for people with developmental disabilities and had worked very hard to overcome that and work on self-improvement.
He already served his incarceration time, right?
Correct. Now he is
Or
out
he's just on parole.
He is out on parole.
Okay.
And Your Honor, although he is now out and with his children again, and with his wife and with his father, he is still at risk of being taken in at any moment for a technical violation. And also parole is onerous. It's interrupting his life.
He committed this crime while on parole. He committed this crime while on parole.
Correct, Your Honor.
So lessening his PRS time, how has he earned that? I mean, he has to show that he can stay on the outside and stay straight. And he gets out and he commits this crime, having a steady job.
Correct, Your Honor. I think that this is a situation where if he were to commit another crime, he would again be in trouble with parole. That's still going to happen if he picks up another case while on parole. The only question is, how long is a justifiable punishment for a non-violent case where he finds a check on the street and tries to cash it?
Okay, thank you, Counsel.
Good afternoon, Your Honors. May it please the Court. Christian Rose for the people. Defendant's challenge of his sentence is foreclosed by his valid waiver of appeal, and it is just for defendant to serve the remainder of his parole the full length of his original sentence, not only because of the reasonableness of his sentence, but because defendant is well served by continued supervision as he continues toward becoming a productive member of society. If there are no questions, Your Honors, and for the reasons stated in our brief, we ask that this Court affirm.
Okay. Thank you.
Your Honor.
Counsel, she's not done.
I'll keep it very brief. If your honors have any questions about the appeal waiver, I'm happy to address that.
We're good. Usually we go past the waiver in this department, right?
Yes.
Okay.
Thank you, Your Honors.
Thank you. Okay, Panasia. Go ahead, Counselor.
Good afternoon, Your Honors. Peter D. for the appellant, Pan-Asia Estates. May it please the Court. The express purpose of New York Real Property Action and Procedures Law, Section 881, is to incentivize property owners to perform repairs and improvements to their properties.
Right, but not at the expense of your neighbor's quiet enjoyment, right? That's why the statute provides for terms that the court deems just, right?
Certainly, Your Honor, but reading that language of what the court deems just to include things such as attorney's fees, for example.
Why not?
Because
if you want to build a structure that could potentially damage mine, why should I have to take your word for it that your plans are okay, that the way that you're going to do the building is fine? Why should I not be able, as the adjoining landowner, to check everything you're doing without having to incur not one rent cent for it? I'm not looking for an improvement. Your client is. So he should bear the burden of that cost for everybody.
With all due respect, Your Honor, the Section 881 needs to be read in conjunction, in this particular case, with the building code, which at Chapter 33 outlines certain protections to adjoining properties. Those protections are the reasons why the petitioner here, Pan-Asia Estates, requested access to those properties. Not for their own benefit, but to...
I'm sorry, your client wants to build above 2 floors. That's not because 2 floors extra look pretty. It's because 2 floors extra bring in more money. Okay, so let's stop, right? That's business, and I'm not begrudging him that.
Sure, but when you look at the building code, it requires that certain protections be implemented into the neighboring adjoining properties.
Okay.
The building code specifically requires that whoever's doing the improvements or repairs ask the neighbors for that access to protect the neighbor's property.
Counsel, it sounds like you're conflating issues. You're talking about code compliance, which is required, but you're not addressing the inconvenience imposed on the adjoining building, the tenants, the unit owners of the adjoining buildings. You're not addressing the loss of use. These are issues that go to damages, right? They're remediated by damages.
Your Honor, I agree that those are issues, although inconvenience for a construction project would apply to pretty much everybody in the city.
I have a balcony.
Except there's a big difference between I'm walking down the street and I'm inconvenienced that I'm walking underneath a sidewalk shed, and there's a big difference between the business owner underneath that sidewalk shed whose front door can't be seen anymore. There's a big difference in the level of inconvenience between those two things, and we're not going to pretend like that's not the case, right?
Well, what we have to do is perform a proper statutory analysis here. Now, when it comes to attorney's fees specifically, you look at the Court of Appeals precedent, which says that the New York State
You
follows...
could have resolved this, counsel. Who started this litigation? You did, right?
Correct,
Not
Your Honor.
you personally, but,
Correct,
but your client did.
because
and
the
issue,
access...
excuse me, don't talk over me.
Pardon me.
The issue here is not a total denial of access. The issue is the terms of the access. The terms of the access. So you don't have two adjoining neighbors who are totally uncooperative and don't want to deal with you.
Here they were. Frankly, in response to our petition, they asked the court to deny our access, flat out. Now, the building code it makes it the responsibility of the neighbors to grant that access. If they don't, then they are responsible for putting up those protections on their own.
some terms, right?
No, actually, if the access is denied, which it was here, then the neighboring properties have to protect their own properties pursuant to the building code.
Right, and your recourse is to do what? To make the license application, right?
Correct.
And then A81 has conditions upon which that application can be granted, right?
The conditions...
And the court gets to decide, that license in the context of terms that are just, right?
But just terms does not include attorney's fees, for example. When you perform...
Why not? I mean, why should they incur any expense hiring a lawyer when they didn't start this. They just want to be left alone, right? You want to build, as Justice Mansonet mentioned, 2 extra floors, enhancing the value of your property. In the meantime, they're going to be tied up for 3 years with a net over at least the 2 owners of that roof terrace are going to have a net over their head. They spent over $4 million for it. They're not even going to enjoy the benefit of that. All because you want to build 2 floors. The legislature took that into account, right? I know you make much of Mayor Lindsay's position, but the fact is that the legislature already took that position into the account by giving the courts discretion to determine what constitutes justice in this case, right?
Understood, Your Honor. With respect to attorney's fees, it's the most glaring issue as far as our position is that when you read the legislative history, when you read the statute and the controlling case law with respect to American rule, attorney's fees were never intended to be shifted in cases under Section...
We have plenty of case law in this department that has approved, again, what if you don't agree in the amount of compensation that a licensor should receive such that they deny you access, and you then have to go to court to seek that license, why should they have to pay for lawyers' fees because you want to build more space on your building?
For one reason, their demands were too high, and the court awarded less than what they were demanding.
That's why we go to court.
Right.
And what the court awarded was less than what they were demanding. So why shouldn't
so all that requires is for us to modify, to not make it 10,000, but make it what reasonable attorney's fees are incurred, right? So we can correct that.
Your Honor, under the statutory analysis that's required, under the Court of Appeals precedent in Baker, under the Supreme Court of the United States precedent in Peter versus NatWest, if the statute doesn't explicitly shift attorney's fees, then you would perform a statutory analysis, and with all due respect, the prior precedent of this court, DDG...
Yeah. We will have to disregard our precedent, trial court's precedents. We have to disregard a lot of policy choices.
Under those prior precedents which shifted attorney's fees, the statutory analysis was simply not performed. The legislative history, the express language of the statute itself says nothing about attorney's fees.
Yay or nay, right?
It says nothing about it, and there's no...
Yay or
there's
nay,
no-
it says nothing, so it doesn't say you can't award them either.
Well, what the statute does say is that the neighboring properties will be compensated for actual damages. And that's expressly in the
Or
statute.
anything else that the court deems just and proper.
With all due respect...
And our precedent has established that for time and memoriam in this city. This is not new.
This is new. Actually,
This is not new.
the statute was passed in 1968, I believe, and only in 2012 have license fees...
Well, how old is DDG
Yeah,
versus
well, look,
Warren?
in
2017.
2014, Judge Mills authored a very eloquent decision where she laid out all of this history, the legislative history, and the reasoning why attorney's fees are appropriate. That case was cited in this court's decision in Van Dorn.
The reasoning in that case said that the attorney's fees was not an incident of litigation, but a condition of the license.
And that's exactly what this is here.
That is a judicial fiction, frankly, and the Court of Appeals would not uphold it based on their current precedents. The attorney's fees...
Well, sounds like you're going to have more luck there, right?
I hope that this court looks at the briefs and takes these arguments into consideration, but it's plain in our reading of the statute and the legislative history that attorney's fees are not contemplated by the statute.
Okay. Thank you, counsel.
Thank you, Your Honors.
May it please the court, good afternoon. Evan Van Leer Greenberg from the law firm of Van Leer and Greenberg for the respondent MKF Realty. Plainly put, Your Honors have a good handle on this. I'd like to make a few notes in relation to some of the facts you may not know. Judge Rackhauer's decision is dated January of 2020. We're coming up on its second-year anniversary. My client was awarded, just from that decision, $15,000 in legal fees. The petitioner has refused and not paid a plug nickel of those fees to date. My client, since then, has had to defend a motion to re-argue, has had to defend this appeal, has had to defend other motions in motion sequences that were before the lower court, and have expended, for construction they did not ask for, over $50,000 in counsel fees. And now I sit here and draft a brief on appeal where the arguments and the controlling decisional law of this court is so clear. It's Van Dorn, it's DDG, it's Judge Freed's decision in PB 151, it's Judge Syada's decision that you guys love and you cite from Brooklyn in Newgarden. And all of those decisions clearly say that license fees were appropriate. When you look at those decisions, parenthetically, they award license amounts $2,000 a month. That's Van Dorn. $3,000 a month, Snyder. $2,500 a month, PB 151. Newgarden, $3,500 a month. They award these lovely license fees. Judge Rackhauer awarded my client's license fees to almost half that amount. I didn't appeal. We just wanted reasonable license fees set. We haven't been paid a lick of counsel fees. If the petitioner had started this construction, parenthetically, and then the pandemic hit, all of these construction materials would have still been on my client's building. And all the people that live in my client's apartments would have been undertaken with all of the protections and the underpinnings and the outrigger systems and the nettings still to this day. So I thank you all, and I appreciate it, and I concede the rest of my time.
Counsel, if you would, please. So both units on both buildings on the side of the subject premises are 6 stories high, and they each have a commercial space on the first floor. Are they similar with respect to the damages that you believe they're incurring, or are they different?
Quite frankly,
are the license fees that you believe that your client should receive? Are they similar to the other building, or are they different?
Quite frankly, Judge Rackhauer did not abuse her discretion. And what I mean by that is this. The building that sits to the east of the petitioner's building is a condominium building, not my client. And they have beautiful terraces. The co-respondents, Daly and Capiccio, have lost apparently all access to all of their outdoor space should the license be granted and construction proceed. It is a different set of circumstances for my client's building. And I would never allege that they are the same or that I'm entitled to equal or more.
Because you don't have the same roof terrace use that the other building has.
That's correct. My client's tenant's use of that roof, it's utilized, but it's not their own private roof deck. And because of that, there's a reasonability analysis. I think the court said in DDG, the question is substantial use and interference. And that's how you contemplate a license fee. And I thank you. If there's no further questions.
Thank you, counsel.
Thank you.
The decisions cited by counsel and upon which this court's precedent is based, which grant license fees, attorney's fees, they discuss how a neighboring party did not ask for this intrusion, and therefore they should get their attorney's fees. I would counter that a tort victim, someone who gets hit by a car or trips on the sidewalk, never asked for that either. But the law of this land, of this country, of this state, does not shift attorney's fees in those cases, and there's no reason to draw a distinction here when, frankly, property owners own property with knowledge of their obligation to grant access to neighbors who perform repairs and improvements. New York is a unique place in that most buildings are...
No, but the policy choices that the legislature has made are different, right? There are instances where you need access in order to, or grant an easement on the circumstances under which some repair is going to be done to a building, some sidewalk repair, some facade, local law issues, etc. This is different, isn't it?
Not really, Your Honor. If the legislature wanted to award license fees and attorney's fees, they would have put that in the statute. They found fit to put actual damages in the statute, and under the...
But that would be obvious. They wouldn't even have to do that. They wouldn't even have had to say that. If you do construction on your property and you damage mine, I'm entitled to damages.
Yet they found fit to say it, and what they found fit not to say was something less obvious, which was attorney's fees and license fees. They expressly left it out. It's found nowhere in the legislative history except for the New York County Bar Association and the mayor's office raised that as an issue, that they objected to the statute because it didn't provide compensation. The legislature passed it anyway.
It doesn't go over any specific types of damages, right? It just...
Actual damages.
Well, it talks about the court having the discretion to decide what's just, right?
What's just in terms of a condition for a license would be no working on Sundays, making sure that people can come in and out of...
Well, you want to limit it that way, but the courts have not read it that way. The courts have read it. You are seeking to improve the value of your property and inconvenience it, therefore, all of your neighbors.
Improving a value of a property improves the value of a street, of a neighborhood. Improvements to my client's property improves their neighbor's property.
Municipalities that are responsible for streets are different.
I understand my time is up, but can I address just really briefly the facts?
I'll give you 30 seconds.
Thank you, Your Honor. Now, putting the statutory interpretation issues aside, the facts of this case, even assuming that attorney's fees and license fees could be awarded, do not warrant it here. In this case,
do not warrant
award of attorney's fees or license fees in this case. Both of the neighbors have performed work on their properties, going on to my client's properties, affixing structures to my client's walls surreptitiously. They didn't even ask for a license. They simply did it, and the court below ignored all of that and just issued a summary opinion.
Okay.
Thank you, Your Honor.
Thank you. Thank you both. Belowski? Se jodió. Le voy a decir a Rosalí que...
Mira.
Yeah.
Good afternoon, Your Honors. My name is Jonathan Edelstein from Edelstein and Grossman, representing the petitioner's appellants. There are several reasons why indicating that Section 237, Subdivision 8 of the Vehicle and Traffic Law should be read broadly to include, among other things, requests for transcripts and requests for the prices of transcripts. First of all, this is a remedial statute. It's the remedial provision of the administrative adjudication statutory scheme, and it's well settled that remedial statutes are to be read broadly. Second, the statute contains a broad, all-inclusive language. It contains the word all, and it contains the word concerning, which the dictionary means in any way relating to. And those also indicate that the statutory terms, the term of inquiry, is to be read inclusively. Third of all, there's no words of qualification in the statute.
Meaning inclusively to include your client.
Well, to include not only my client, but yes, certainly to include my client.
Right, so because I wanted to address the issue of standing first, right?
Well,
I mean, who should be benefited by the prompt transcript?
Well, first of all, Mr. Belowski is not the only petitioner. There are other petitioners whose standing is conceded. So even if this court were to find that Mr. Belowski, as president of PSE, does not have standing, the statutory interpretation issue is still before it. If the court wants to discuss Mr. Belowski's standing at this point, well, we submit that he has standing for the same reasons that the plaintiff in the NYDTA case had standing in federal court. The NYDTA case is actually a ticket broker with functions very similar to Mr. Belowski and PSE. And it's been alleged that PSE, because of the conduct complained of here, has sustained administrative burdens and expense burdens that are borne by PSE itself, cut directly into PSE's bottom line, not borne by the clients. This is an injury not suffered by the general public, and to the extent that counsel has argued that an interest and an injury are two different things, the case law that counsel cites makes clear that the difference between an interest and an injury is that an injury is suffered by the plaintiff or the petitioner as opposed to the general public, and we've certainly satisfied that here. And
so you argue you are within the zone of interest.
Yes, and as to the zone of interest, we've argued that the ability that representatives such as PSE are central to the way the commercial adjudication unit of the PVB works. Without representatives, and if the representatives are not able to do their jobs, the CAU would cease to function, because it does volume adjudication of commercial vehicle owners. And if all of the vehicle owners had to send people to defend every ticket one by one, the system would grind to a halt, and business in the city would grind to a halt. So the zone of interest we would submit, and I think the NYDTA case supports, includes the ability of petitioners such as Mr. Belowski and PSE, ticket brokers, to be able to do their jobs and to not be subject to improper administrative burdens and expenses due to the respondents violating their statutory duties. And again, we would submit that there is a statutory duty to respond within 45 days to all relevant and reasonable inquiries concerning the NOV. And for the reasons that we've stated, the remedial provisions of the statute, the use of the broad words such as all, the lack of any qualifying language limiting the scope of inquiries to any type of inquiry or to any stage of the case, whether
Counsel,
before or after appeal.
would you kindly parse the difference between request and inquiry?
Well, an inquiry is a type of request, and in fact, counsel has conceded that in their brief. They define an inquiry as a request for information. A request for the price of a transcript is certainly a request for information, and a request for the transcript itself is also a request for information, because the transcript contains the information of what happened at the hearing, which is necessary to prosecute an appeal.
But Section 237 dissects those requests into different subsections, don't they?
Well, but...
Counsel, answer my question, yes?
Yes, they are different subsections.
And subsection 6 relates to the issue of the transcripts, correct?
Correct.
And Section 8 relates to notices of violation.
Well, Section 8...
You seemed in your argument to conflate those two things, and they have separate provisions that guide both of those different items.
Well,
Doesn't the statute break it down?
Well, I would submit that the statute has to be read in harmony, and that 237...
But I have to read the section, so Section 6 talks about, which relates to the issue of the transcripts, which is the issue here.
Yes.
The issue that you say the city violated was with respect to not providing either the cost of the transcript or the transcript itself, right?
Correct.
None of these relate to notices of violation, which is governed under subsection 8.
Well, a transcript or a request for the price of a transcript clearly do relate to the notice of
Except that they are, counsel, I understand that. But when a statutory, when we have statutory guidelines that tell us that under the one subsection deals with one item and another subsection deals with another item, you cannot conflate them.
Well,
unless there's other language in the statute that says that you can. Point to me where it says that then.
Well, I would disagree that the two are separate or that I'm conflating. And
one
if
is
I
6 and one is 8. One tells you you have to do this by this time, and if not, you cannot proceed to hearing until you've done so 10 days earlier. And then Section 8 is the only section that says if you don't comply, then the case is dismissed.
Your Honor,
separate sections.
Your Honor, I apologize, but if I may explain without being interrupted by the court.
Well, no, wait a minute. You see, you don't get to interrupt the court. So I am completely entitled to complete my question and my statements as I see fit.
Your Honor, but then I would like to be able to answer the question.
Well,
I have not been able to finish a sentence.
Being scolded by you.
And
it's time to do it. Counsel, just do it. You have a red light on, so I'll give you a minute to do so. Okay?
Yes. Our position is that subdivisions 1 through 7 of this statute are a list of duties. Remedy is not provided in those sections. The remedy is provided in Section 8. Section 8 is a catch-all. It is not a conflation. Subdivision 8 talks about all reasonable, relevant and reasonable inquiries. That would include the inquiries that are discussed in the previous sections of the statute. And Subdivision 8 provides a remedy, which the previous sections of the statute did not discuss. Duties, remedy. The two of them are to be read together. It's not conflating.
Okay. Thank you, Counsel.
Thank you, Your Honors. I reserve my time for rebuttal.
Good afternoon, Your Honors. Julie Steiner for the respondents. The threshold issue that this court should address is simply that Mr. Belofsky does not have standing. It's a threshold issue that routinely comes up with this particular petitioner, and it must be addressed and resolved. He does not have standing because he's a broker with no actual interest, within the zone of interests. His claim of lost time, money, and resources, that's just an interest in the proceedings. It's not an actual injury. And even if it were an actual injury, Your Honors, it's not within the zone of interests. The zone of interests of this statute is the provision of basic due process rights to those charged, with a notice of violation. and that is not him. His due process rights are not violated in any of these matters, and as such, he does not have standing.
Is there anything that prohibits a company such as the petitioner here from having this business, operating this? Is there anything that prevents them from operating this business and representing people with lots of parking tickets like businesses?
No, not at all, and that's not, Your Honor, that's not what we are contesting. He certainly has the right, and I believe the vehicle and traffic law even gives him that right to represent these individuals, but he, as that broker, cannot stand before this court and try to say that these provisions violate my client's due process rights. It would be just as if I, as an
But his clients can, right?
his clients can, and we are not, and we are certainly not contesting that. And so, regardless of whether you agree with us that Mr. Belofsky does not have standing, agrees with that he does not have standing, regardless, the Supreme Court was correct in finding that as to all petitioners, Mr. Belofsky, as well as the other, his other clients, that 237.6 and 237.8 do not require dismissal of the tickets. As Your Honor pointed out, there are two separate sections. And in each section, the legislature intentionally used two different words, request and inquiry. And the rules of statutory construction require this court to read into those words their commonly used definition, so as not to render any one of them superfluous. It is no mistake that the legislature used request every time the word transcript was used, and it used inquiry for other things, not a request for a transcript. And if this court were to read these or conflate these two terms, it is in fact doing exactly what the legislature could have done, but chose not to. The only time a dismissal remedy is indicated anywhere in the statute is in 237.8 with respect to a request for a copy of the violation or inquiries concerning. An inquiry concerning the violation is not a request for a transcript, which is a request for something. And if the plain language leaves any doubt, certainly the legislative history puts all these issues to rest. The legislative history, or the purpose behind this vehicle and traffic law section, was the basic provision of due process. And so,
Am I right that 237.1 through 5 are merely duties and responsibilities?
Well, the entirety of 237 speaks to the functions, powers, and duties of the PVB.
Right. But I'm saying with respect to items they have to provide, it starts at 6.
Well,
because everything else is policies, taking pleas, etc.
And 5, for instance, says to enter judgments. 6 is to compile and maintain transcripts. Right. So these are all their duties. Mm-hmm. The only time one of these duties warrants a dismissal is subdivision 8. And the language cannot be any more clearer in there when it specifically says a failure to comply with this subdivision. This subdivision is 8. It's not 6, it's not 4, it's not 5, it's 8. And 8 only talks about requests for a copy of the NOV or an inquiry concerning the notice of violation, which is not the same as a request for a transcript. We must look to what the legislature intended by its plain meaning, and request and inquiry are two different words with two different meanings. Thank you, Your Honors.
Thank you.
Briefly, Your Honors, since counsel mentioned the legislative history, that legislative history includes the Senate memorandum, which in its discussion of subdivision 8 says that the intent is to require the PVB to answer all certified mail concerning a reasonable inquiry, quote, in relation to the case. That, again, it's not merely to guarantee due process and to guarantee access to information, but to ensure that the due process and the access to information have teeth, and to require all inquiries, answers to all inquiries in relation to the case, which cuts against any kind of a narrow reading of the term notice of violation, especially with the words all and concerning also in the subdivision.
So you're saying that a request for a transcript is an inquiry in relation to the case?
Yes. Well, Your Honor, I would point to page 21 of the respondent's own brief, which defines inquiry as a request for information. So the whole notion that inquiry and request are two completely different things is refuted by their own arguments. They characterize an inquiry as a type of request. And an inquiry for the price of a transcript. How is the price of a transcript not information? How is the transcript itself not information? So a request for information includes these things. And finally, as to standing, I would submit that, yes, the VTL and also the rules of the City of New York do give brokers like PSE the right to represent their clients' interests in the commercial adjudication unit. And to the extent that the function and the zone of interest is to guarantee due process to the owners, due process to the owners hinges on the ability of their representatives to do their jobs, just like you can't separate due process to a criminal defendant from the ability of counsel to function as counsel. So
Thank you.
I will rest on the briefs, Your Honor. I'm out of time.
Thank you both.
May it please the court, Your Honors. Good afternoon, Andrew Goldenberg for Appellant EDF. This appeal is about a license agreement. It's a 20-year license agreement. It's an exclusive license agreement. It contemplated $180 million in guaranteed minimum sales. And after cashing $150,000 as an advance, the defendants tried to get out of the agreement. And they had a plan. The plan was simple: to use and abuse their discretion by intentionally delaying and withholding approvals. Now, I know I have limited...
Those were the agreed upon terms in the contract, though. You knew going in that the defendants here had sole authority to approve all designs. And if, according to the contract, if approval was not given within a certain time, it's deemed not approved.
That's correct,
So
Your Honor.
I don't understand the problem.
The problem is, Your Honor, that sole authority has limitations. It's not unlimited. Discretion to review and approve products is not unlimited. And this comes out of
What limitations were included in, because we're guided by the contract.
Correct, Your Honor.
Right? So what limitations on that sole approval were there? Tell me what they were, because I didn't see any limitations.
Well, there are limitations. The limitation is that every contract, including this one, has an implied covenant of good faith.
Of course.
So you can't just take hundreds of products, review them, and say nothing of it. Don't say approve, don't say disapprove, just do nothing. That's
Except
a classic
where the
example.
contract says if I don't approve, it's disapproved.
That's correct, Your Honor, but just like in
So that is saying something, isn't it? Under the contract, silence is rejection.
Right, but in order for the other side to perform here, you need a response, you need approvals, you need something.
No, but why? When the contract itself doesn't require it. I mean, listen, you're contracting for a big artist, a famous artist, likeness, and reputation. So they're going to scrutinize everything that you submit for approval, right?
Correct.
Under Section 8, you have that two-step process.
Correct.
Right? So if their failure to respond, as Justice Nancenet mentioned, their failure to respond means she's not approving. I know that sounds like somewhat arbitrary, but that's what you contracted for.
Your Honor, you used the exact word that I was about to say. It is arbitrary.
But you contracted for it.
Right, but
you went in, I mean, there's no out of that provision, right?
There is no out, Your Honor, but this goes to the Dalton decision from the Court of Appeals. You can't act arbitrarily or irrational. You can't intentionally withhold everything.
Also, you can't say yes, but.
You can say no.
You are in control of what contracts you enter, and you are bound by the language you agree to.
Correct.
The other side bargained for complete control of the product.
That's
And
correct.
that's what the contract guaranteed them, and it was your client that violated that.
Your Honor,
By putting items into the marketplace without approval.
Your Honor, actually, the record shows that those items that were out in the marketplace were internally approved. There's testimony from Talia. There's testimony from her assistant. There's an email from Mr. Mottola, her husband, sending an email to their future partner, ABG defendant, saying, this is looking great. They said all those things internally. They liked everything internally, but they didn't commute to their actual partner. They communicated to their future partner because they wanted to upsell a partnership. And I just want to point the panel to the age group decision issued by this court, because the facts there are exactly the same. You had a license agreement, it was exclusive. You had an approval process. That approval process required that the licensee give products to Martha Stewart. Martha Stewart had to review and approve or disapprove. And there the court held she didn't approve anything. She intentionally withheld approvals, and the court determined that that was an act of bad faith. There again, the court determined...
That's not the case here. There were items within things that were submitted by your client that were approved, and then other items that were not approved.
That's not the case, Your Honor. The record shows, for example, initially 69 items were sent out for review, and the opposition is silent as to the 69 items. Nothing was sent back. But internally, Talia says, they looked really cool.
Wait, hold on, counsel. Are you saying that every single thing that you sent over to them was not approved?
I'm saying that many items were approved internally,
were some
but were
items
not communicated.
That's not my question. Were some items approved?
From the initial round of production, no. I do not, of the 69 items.
Throughout the relationship, were any items approved?
In the record, I don't believe so, Your Honor.
So how has your company made $4 million worth of profit on products that weren't approved?
They have not made $4 million on profits that
Really?
are approved. The contemplated sales didn't even come close, Your Honor, because at every step of the way, approvals were withheld. Product categories were removed or attempted to be removed. There is ample evidence in the record that the licensor attempted to do direct license deals behind the licensee's back with exclusive retailers. The record is ample, has ample evidence of bad faith, yet all of this was overlooked by the lower court. And as far as the approval process, in which the licensor spends many pages on in their brief, that approval process required step number one. The licensor, not the licensee, provide a form. That form would be used for product submissions, but no form was ever provided. Why? The parties decided that there was a more convenient way to submit concepts through email, through Dropbox, to submit pre-production samples by FedEx without the form submission. And then midstream, the ABG defendants come on and say, guess what? We're going to use a software program now. That's not contemplated in the agreement, yet the parties said
why
nothing.
not? Because it had to be approved in writing, right? It doesn't say that it has to be a hard copy approval. Why can't it be electronic approval?
It can be an electronic.
An email.
That's my point, Your Honor, is that you can substitute whatever means is convenient for you. So to strictly apply that Section 8 of the license agreement, when the parties didn't actually do that, would be inconsistent with the record and inconsistent with the law. I'll reserve my time.
Good afternoon, Your Honors. May it please the Court, my name is Jamie Burkell from Prior Cashman on behalf of the respondents. There's a few points that counsel made that I'd like to address. I think the questions that the Court has posed address many of the issues that we would want to...
So can I just ask you at the outset, were any items approved?
Yes, there were, Your Honor. In fact, what happened, if you look at the sequence of events, is that there were material breaches by EDF early on in the relationship, and we terminated the agreement. And then we sat down with them and said, listen, we're going to try to make this work, but you've got to honor the rules. And the rules are that we need to approve these things before you put Thalia's name and likeness on goods that go into the market. And so things that they had done improperly early on in the relationship, we let them continue to sell. But we said, going forward, you have to honor the terms of the agreement. So what did they do? They started selling swimwear. They started selling athletic lines, neither one of which they even presented to us. They can't say that we, in bad faith, didn't approve these things. They never presented it to us.
And isn't it with the bathing suit line that they utilized the image of Thalia and put it on another model's body?
Yes, that's what I was about to say, Your Honor. They literally took a picture from the photo shoot, to the extent that they're saying she didn't cooperate. She went to a photo shoot, they got a picture of her face, and they took it and put it on another model's body. And they put it in a catalog in Mexico and never sent her the picture to approve. It was grotesque. They took her face and put it on somebody else's body. And they're saying that they didn't breach the agreement, or that for some reason the court was in error in finding that they materially breached. Not only did they do that, but after we terminated, it was expressly provided in the agreement that they couldn't sell off their goods. They sold off and made a couple of $1 million selling things that we hadn't approved. Now, as far as the Martha Stewart case is concerned, it's fairly clear that they're trying to fit a square peg in a round hole. In that case, a distributor deliberately cut out the middleman, the one that they had a contract with, and did a contract with their own licensee. And in the process, basically said, we're not going to approve anything that you present to us. In our case, we said we will approve things if you present it to us and give us an opportunity to review it and comment on it. There's no evidence that we unilaterally decided that we weren't going to approve anything. And making matters worse, in this case, there's no agreement that Thalia or her parties ever entered into with a third party in Mexico that cut EDF out of the process. So they're trying to say this fits within the case.
But they were saying there were negotiations between Thalia and her company and other folks in Mexico. Is that not true?
No, so what they're doing is they're trying to take a benign fact and make it look evil. What happened was Authentic Brands, which bought into Thalia and Tommy Mottola's business, represent a number of artists who are interested in getting their products into Mexico. So one of their representatives went down and met with a number of companies in Mexico on behalf of all of their artists. Thalia was one of their artists. It led to no agreements. They certainly never met with Price Shoes, who was their licensee. So to try to make it sound like the Martha Stewart case, they keep arguing that we cut them out. We never cut them out. We never dealt with Price Shoes. Anyhow, I'll be available if you have more questions, but I think I've made my points. Thank you very much.
I think we're good. Thank you so much.
Your Honors, to Mr. Burkell's last point, there are at least 3 examples of attempts to negotiate direct licenses with exclusive retailers covered under the license agreement, including Price Shoes. If you Google Thalia Price Shoes, guess what? She's doing a DTR right now with Price Shoes. And the record shows on page 770, on page 718, that defendants contacted exclusive retailers behind EDF's back. They had a secret trip to Mexico. The email says DTR, and it lists exclusive retailers. So to say that this is factually an opposite from Age Group, this is exactly on point. In Age Group, the same thing happened. They tried to do a direct license, and this court affirmed the lower court's ruling that that was a sign of bad faith. There were issues of triable fact that required it to go back to the trial. And as far as the words material breach, this is basic contract law. When a party, a non-breaching party, claims that there's a breach, they have a choice to make. They can terminate and seek damages, or they can elect to move on. At each step of the way, the defendants elected to move on, and by doing so, it's not a material breach, it's a partial breach. They can put the other side on notice, and they can say, look, you caused me damages, which, by the way, there's been no evidence of damages here whatsoever. But that's not what they did. Every single time that they threatened termination, they decided to move on to falsely assure the licensee that everything's going to be okay. We're going to take some products, we're going to review them, and we're going to get back to you. But they didn't. And I didn't hear anything from Mr. Burkell in the record that shows that products were actually approved and communicated the way that they should have been under the license agreement. We're talking hundreds of items, hundreds of items. So it's not a material breach. Those 3 items out of hundreds that were the swimwear and the sportswear, that was 3 months before they terminated. And you know why they terminated? They terminated because we sued them. One day after we filed our complaint, all of a sudden there are 3 items. All of a sudden there's a facial image that was, by the way, provided to them by mail in a catalog. And if anything, they say they never got it. We submitted an affidavit that they did get it. That's an issue of fact. There are many issues of fact that should be brought back to the trial court to be decided, not on this appeal.
Thank you, counsel. Thank you both. People versus Woodley. Yeah, but they submitted. Go ahead, counsel.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent Mr. Macliff Woodley. To begin, I'd like to make a few points on the issue concerning complainant's psychiatric records. 2 days before trial began, the complainant disclosed multiple diagnoses of mental health conditions, including bipolar disorder, PTSD, and OCD. In light of these disclosures, the court completely mishandled the situation, violating Mr. Woodley's right to a fair trial. The court never reviewed the complainant's full psychiatric records, only those of a nurse practitioner who started seeing the complainant only 3 days prior to the incident in question. Excuse me.
What do you think the court was missing from the psychiatric records?
Sure, so I think
that led the court to impose what seemed to be reasonable limitations on cross-examination.
Absolutely, and I think it's important to understand that there were 2 known psychiatric providers at trial. There was this nurse practitioner who started seeing the complainant 3 days before the incident, and there was a Dr. Kava who had seen the complainant for 2 years prior to that, with a short break in between the 2 practitioners. Now, the current practitioner...
That short break, counsel, wasn't it 6 months?
I believe it was 4 months, Your Honor.
Okay.
Now, the current practitioner had no idea of these diagnoses of bipolar disorder, PTSD, and OCD. The current practitioner had no idea where they came from, guessed that they were self-diagnoses. So that ambiguity alone creates a very big question of where did this come from? And so that, in and of itself, means that there was something missing here which could have been answered by these missing records of the prior provider. But
isn't that, I don't know how to characterize it, a little fishing? I mean, the reality is, all of those records have to be examined in the context of what, if any, conditions deal with the issue of violence on the part of Mr. Allen, right?
Exactly, Your Honor. And it really goes to his credibility, and I think this is where it's particularly important, because the complainant was saying, I have these diagnoses. His current provider was saying, I have no idea, this is what I was seeing him for. And there's a prior provider not too far back in time who could, shed light on this pretty enormous discrepancy. And I think the discrepancy in and of itself goes to the complainant's credibility, and defense counsel should have at least been able to cross-examine.
Credibility on the issue of what? Because I certainly understand as a defense attorney wanting these records as potential, fruit for cross-examination. I get it. But they go to what issue in this case, in the overall scheme of things, in light of the video that shows us exactly what happened?
So before answering your question, I just want to say that there is no video of the fight itself. There's a video of the verbal altercation here.
Okay, and a bleeding victim, right?
I believe they're just photos of the complainant afterwards.
Okay.
But the actual fight itself, there is no video. So that means that complainant's testimony and credibility here is really at stake, and being able to cross-examine, like I said before, even just about this discrepancy, you know, he's saying something about his mental health, and his current provider is saying, I don't know what he's talking about at all. That right there leads to some questions about credibility, reliability.
But I mean, it's going to what? That this complainant misperceived something, that he wasn't actually under attack by the defendant here. I mean, I'm trying to get to credibility on what issue, whether it was whether he should have gotten as excited as he did. I'm trying to understand what to correlate those records to what you think they could have established that you weren't able to establish through just examination.
Absolutely, Your Honor, and I think you touched upon two of them very well. Perception of surroundings, being able to accurately convey what happened that day, perception of how, you know, violence or just a previous behavior as such.
What about the other witnesses that testified to precisely that?
Mhm.
To the defendant's behavior in the subway car and how he was walking up and down and, in essence, harassing other passengers.
Sure, Your Honor.
And that he was the initial aggressor.
We're not contesting at all that Mr. Woodley was on the train, walking up and down, preaching. The various descriptions of his behavior do vary from witness to witness. You know, someone said that he was having calm interactions with other passengers. Other people said that he was animated. Other people, in fact, or one person in particular, in fact, said that Alanin stood up, walked over, and blocked his path. So the evidence is certainly not overwhelming when you have multiple different witnesses giving varying accounts. And so that means that the complainant's testimony and credibility were particularly important here. There are no further questions. Reserve my time on rebuttal.
Good afternoon. May it please the court. Rachel Bond for the people. I'd like to start with the psychiatric records issue as well. Defense counsel did not offer any sort of good faith basis for believing that the victim had psychiatric history of violence or disorders that would tend to make someone violent. And in fact, even if he had, those records and those issues could not be used to show the complainant's violence in terms of the justification defense, because they were strangers to each other. They didn't know each other, so the defendant wouldn't have known any of those things as this altercation was going on. Additionally, the nurse practitioner, although he did say, I'm not sure where those extra diagnoses are coming from, he also specifically told the judge that he didn't see any symptoms of those disorders in the victim. So not only did he say, I don't know, he said maybe those were diagnoses he got in childhood, potentially. I don't see any of those symptoms in this victim. He also, the judge specifically told the parties that he asked about those diagnoses, whether those would have any impact on violence or credibility, and the practitioner said no. And any argument that the court should have gotten previous psychiatric records falls flat as soon as defendant says because they could have contained potentially vital information. The defendant doesn't have any good faith basis of any specificity that these records would have made any difference in terms of the complainant's credibility. And not only that, the lack of psychiatric records being turned over and the limits on the scope of cross-examination did not prevent the defendant from presenting a full defense. He impeached the victim's credibility, cross-examining him about his criminal history and prior inconsistent statements. And quickly on the weight of the evidence and justification, I would just like to point out that the people's witnesses were consistent about every essential fact here, that the defendant was loud and aggressive on the train that day, that he was the initial aggressor, that he escalated to the use of deadly physical force, that he willingly engaged in the fight, and that he fled as soon as police were announced to be on the way. And for all these reasons and those in our brief, we would ask that you affirm.
Thank you.
Very briefly, Your Honor, the fact that the current psychiatric provider didn't see any symptoms and couldn't say anything almost reinforces, of the diagnoses that the complainant disclosed, almost reinforces the point. It's just a question of where did these come from? If the defense counsel doesn't know where they came from, they won't be able to accurately cross-examine anything. The court simply should have ordered records from this prior provider, who was known to the court, and made that decision. Perhaps there was nothing in them that was relevant, at which point the court would rule, I'm not disclosing these records to you. Simple as that. But the court necessarily had to order them since there was a good faith basis. This good faith basis was this complete mismatch in what his current provider saw and what the complainant himself was disclosing to the court. For that reason, if there are no further questions, rest on my briefs.
Thank you.
Thank you, Your Honor.
both.
This is it.
May it please the court, my name is Tom Lambert. I have a 90-second argument and respectfully ask to reserve the remainder of my time, if any, for rebuttal. There is evidence, witnesses' attestation, and proof in the record that in plaintiff's apartment, there is the excessive sound of machinery, including pure tones, coming from the adjacent mechanical equipment room of the building, which, regardless of decibel level, is disturbing of the peace, comfort, and repose of a reasonable person of normal sensitivities, and renders the apartment unusable for sleep. There has been no denial that these facts meet the statutory criteria of unreasonable noise prohibited by New York City Noise Code, sections 24218A and 2420362. And remarkably, there is no witness, no evidence in the record which denies or questions or otherwise puts these statutorily dispositive facts into issue. Plaintiff notes that these sections apply independent of the decibel levels of the offending sounds. Defendants claim otherwise. The court below did not expressly say.
Oh, counsel, you're seeking a preliminary injunction, right?
Wait, I didn't hear.
You're seeking a preliminary injunction?
Are you seeking a preliminary injunction?
Yes, that would entitle, yes.
If you obtain the preliminary injunction, does that grant you your ultimate relief?
The preliminary injunction seeks nothing more than directing the defendants to comply with the code. So if they're in compliance with the code, everything's fine. But this woman, the plaintiff, is admittedly suffering from being in an apartment where she hears the noises of the mechanical equipment room, which prohibits sleep. There's nobody that denies that. The only thing the defendants have tried to do is say that there's an issue of fact as to whether the decibel levels exceed this or that in another section of the code. But it doesn't matter whether the decibel levels are up or down. The nature of the sound is maddeningly disturbing because they're pure tones. And their experts have a report in the record, which at 514, I believe it is, where they're saying, I can quote that, their report says the noise impact from mechanical equipment upon a residential space in New York City must be free from pure tones, that pure tones are not permitted regardless of the overall noise level. So everybody's agreed. The only defense here. The only thing is that they're claiming that you cannot have a violation of the noise code unless you have proven that the decibel level of the offending sound exceeds a limit that's set in some other section of the code. But the code was amended expressly to eliminate any thought like that.
But aren't these all issues that have to be parsed out at trial, counsel?
Judge, sometimes, I mean, it's amazing in this case.
The only way,
sometimes the facts.
The only way to stop the noise is by stopping the machinery, right? And it would have to be relocated someplace else in order for the building and the hotel to function.
Yes.
So I go back to my original question. Isn't it true that if the preliminary injunction is granted, you then obtain your ultimate relief?
Sorry. I'm sorry about that. Judge, they put this mechanical equipment room in there against the advice of their architects in a way which was guaranteed to cause the disturbance in the residential apartment.
Let me ask you.
Now that how they have to fix it,
Counsel,
the court can't take that on. I'm sorry.
Your client purchased this apartment
Yes.
prior to the building going up.
Yes.
Correct? I would assume, as is customary, that she was shown building plans and exactly which unit she was buying and what was next to her unit. Was this mechanical space not apparent on the plans she saw when she bought?
I'm sure it was. And that's why we have no claim, and I told her that right away. There's no claim for fraud or anything like that. She could have had this inspected, and she happened not to know, because she's just a lady, just a person like the rest of us. She wasn't, and she didn't have an inspection. But that's not the point, Judge. There's a code.
No, I understand. I just wanted to know
that's correct. No, there's
whether
no
there had
fraud
been a
claim. No,
switcheroo.
there's no fraud claim. But these guys put that room in there and designed it in a way against their architect's advice, where they knew that there was going to be a problem. And now there's a problem, and now they're coming and telling the court below how difficult it would be, what the hardship would be to them. And that's supposed to be a balancing of the equities, because it'd be a hardship to them to have to undo what they did. Well, buy the lady out, do whatever you have to do, but it's not the court's problem, and the court can't take it on by failing to enforce the noise code.
We got it. Thank you.
Thank you.
Exactly.
Good afternoon, Your Honors. Remy Stocks for the respondents.
Is there a tribal issue with respect to the pure tones that counsel is referring to that do not require a decibel count?
What we have, the pure tones were abated. The only evidence in the record is that the last evidence in the record is the August 27th report, 2020 report of respondents expert Sarami that shows that the condenser water pumps, which were the undisputed source of the offending noise, were operating within permissible levels. There is no evidence of pure tones after these adjustments were made at all. Appellant's first complaint of noise from the building's mechanical room on July 31st, 2018, over 2 years before seeking an emergency injunction and a temporary restraining order in October of 2020. The lower court properly denied her application, finding she had failed to demonstrate a likelihood of success on the merits, irreparable harm, and that the balance of the equities was in her favor. During the 2-year period between appellant's initial noise complaint and the commencement of this lawsuit, appellant's expert and respondents' multiple acoustical and engineering experts conducted extensive testing of the sound levels in appellant's apartment emanating from the mechanical room. Respondents spent hundreds of thousands.
Were those tests done in her bedroom? or in different parts of the, because quite frankly, her complaint is she can't sleep. So the fact that the decibel level in the living room is okay is irrelevant. She doesn't sleep in the living room, she sleeps in her bedroom. So were these tests done in her bedroom?
Yes, they were done pursuant to a protocol developed between the two experts. Yeah, it was just the bedroom as far as I know.
Okay.
Okay, thank you, counsel.
Thank you.
Okay, you got 1 minute, counsel. Okay, thank you.
Thank you very much. Okay.